Yes.
Lord Sir, I beg to mention item number 22 and 23. A request has been made by Mr. D. Das, Senior Advocate, to post these matters on 26th of June. To post this matter on 26th of June.
Why?
Mr. D. Das is available on 26th and he has requested this court to
Huh?
post this. He has requested to post these matters. 22 and 23.
What is the matter?
It's a compensation matter regarding compensation matter
Basically,
for PFs. Compensation was made to the PF project after families, and these are the ladies who have been married to other areas, and they are claiming. That is the case. So on 26, it can be disposed of.
can be disposed of that.
Hmm?
I'm for the petition.
On the prayer of Mr. K. Saxena, Learned Counsel
For private respondents,
I'm for the petition.
respondent, private response.
4 and 5.
Respondent number 4 and 5. And prayer not being objected to by Mr. S. Learned Counsel for the this matter after 3 weeks.
That's 26.
3 weeks.
26.
3 weeks. Why?
Otherwise, Millet, in this matter, there's
Okay. Your pleadings are complaint.
No,
especially in the one writ petition 212. of
government has to file the
2025,
affidavit.
Government is yet to file.
If they are not filed, have the question of disposal.
Yes. So I think they
3 weeks.
I'm
In the
informed-
meantime, the respondents may file their
I'm
response.
informed that they don't want to file the affidavit. I don't know if
Those
is it.
people will not be filing
Why?
because those people in the one past written petition also.
Ah.
They have already filed our affidavit.
So-
Yeah, similar method.
Why? What's similar? Why 2 writ petitions?
Millet, two writ petition, Millet.
One has
What?
become infructuous actually.
One writ petition was filed after challenging in the first writ petition.
For inclusion,
Yes.
the list of affected
Yes.
families. Then
Direction was to Deputy Commissioner that representation filed by the petitioner should be disposed of within within 1 month.
include. The first one is for inclusion.
Yes.
What happened there?
No, the first one is
Deputy Commissioner has resigned. No,
Huh?
Deputy Commissioner has dismissed their representation.
Ah.
and we challenge that one.
That
And
is
that
the-
is the second writ petition.
Second representation is challenging the order of the Deputy Commissioner.
Then why were saying it's infructuous?
No, first one has become infructuous
No,
because
first-
representation was to
first-
disposed of.
first
That is
one
disposed of.
Huh?
That is disposed of already.
No, on the first one only there is an interim that money should not be deposited to the third parties. That's how the matter is still existing.
Why? The Deputy Commissioner, if you are not entitled, you may be from that particular village. It doesn't mean that you are affected person.
Yes, project affected families.
Well, in this case, matter basically they are the daughters of the head of the families of the particular
Doesn't
village.
matter who is disputing that. You have to show this particular land has been acquired, which belongs to
No,
you.
well, basically this is
And
that
Deputy Commissioner is the best person to know whether you are entitled to compensation or not.
well, basically that is a community land.
Huh?
Community land. Community, not individual land. It's
Then it's a, if the community is not included, what's the government and the authorities gonna do it? Well, they are got to do it. It's between you and the private individuals, respondents.
So they're same footing, Malad. They are also the same footing.
Who
The private respondents and the
are not concerned. If you are disputing the entitlement or the ownership of that community land, it's a dispute between you and the private parties. I mean, private respondents or whoever claiming it.
Civil suit.
no, basically in this matter, Deputy Commissioner.
First, sir, you have to establish that this particular land which has been acquired belongs to you. Then you will be allowed to directed to be included. What is the reason ground of Deputy Commissioner rejecting your application?
Application was that only that it was they have not filed the representation in time. That was the only issue.
Huh?
They have not filed the representation.
During
within
the claims
within the
and-
period.
during the claims and
30 days,
objection.
that is the only issue.
During the period of claim and
That
objection.
Yes.
hearing, because they were not in that.
No, otherwise it's purely disputed. How do you say that, how do we know that just because you are the village, you are daughter of that thing, you will be entitled to come?
There is a lordship, your lordship
You are
may
not
decide,
interested in the ownership, you want the money only, that's all.
lordship may decide
You
on
cannot-
26.
List after 3 weeks, huh? No, the last line, the affidavit. and-
Lordship can decide this matter on 26.
Huh?
You will be the best person.
We'll
to
decide today if you are ready.
Very well, yes.
Huh?
Well, in this matter, Majumdar sir is appearing this matter, so he also agreed.
After 3 weeks. Huh? To make it after 2 weeks.
It will be same, it will come after only a vacation.
Huh?
It will come after only vacation then.
We have 2 weeks now.
After 2 weeks, please.
More than 2 weeks we have.
Obliged.
After 2 weeks.
Obliged.
My lord, I'd like to mention item number 24.
Hmm.
As my senior counsel is out of station.
What senior counsel? Who is your senior counsel? Everything is finished. Election, appointment, everything is done. Who is for Public Service Commission? Who is appearing? Who is your senior?
Tito Puz.
What remains here? Anybody for Public Service Commission? Item 24. No, item 24. Anyway, on the prayer of Mr. So-and-so, learned counsel for the petitioner, list this matter after 3 weeks.
Your lordship, item number 8. The senior counsel for the petitioner is absent today, your lordship. He travels from Delhi.
Huh?
The senior counsel for the petitioner,
Huh?
so S. Ghosh, he is absent today. He travels from Delhi, so due to personal reasons, he could not be present today.
On the prayer of Mr. So-and-so, learned counsel,
Your lordship, if it can be
appearing
listed
on behalf of Mr. What is the name of that?
S. Ghosh.
S. Ghosh, learned counsel. On the ground, and on the ground that,
Your lordship, interim may continue, your lordship.
on the ground that Mr. S. Ghosh has some personal difficulty, come on. Press for, list this matter after, no,
Your lordship, if can be
press
listed
for an
on
adjournment.
August.
No, only prayer, I said only prayer, so-and-so, on the ground of so-and-so, so-and-so. List this matter after 4 weeks.
Your lordship, if it can be listed after, on second week of August, your lordship.
For 3 weeks, interim order passed earlier shall continue. Yet,
Interim may continue. Oblige, your lordship.
May it please your lordship,
Yes.
I would like to mention item number 32. I've taken consent from the other side, government. So I want this matter be listed after 3 weeks, your lordship.
Why?
Your lordship, we are fighting difficulties regarding steps to taken to respondent number 9, still awaiting.
On the prayer of Mr. So-and-so, Bhattacharya Land Council will list this matter after 4 weeks.
Obliged.
May it please your lordship.
Yes.
Challenge herein is against a tender process for supply. Now, if your lordship will kindly come to page 23, this is a clear case where I have been deprived, even though the tender evaluation committee has found me in all counts to be the most valid and responsible bidder. Your lordship will come to page 23. Page 23, lordship.
What is there?
Yes, lordship. Now, lordship will see at serial number 1, this is a supply of materials under the MG NREGA, and the block is Sagali CD block, Papumpare district. So this is a supply order. Now, if your lordship will come to clause 1.1, The work is estimated to cost 11 crores 25 lakhs 22,639. Also, will kindly mark this. The estimate, however, is given merely as a rough guide. Also, will kindly mark this. This estimate that they're talking about, they themselves in their NIT says that this is a rough guide. So it is not a sacrosanct figure, it's a rough guide. Now, if your lordship will come, I'm just placing the clause so that I can thereafter show as to how the authority.
Please, it's a motion, don't waste time.
Yes, yes, lordship.
Tell us why, how, what is the reason of?
Yes, therefore I have to show this clause, lordship. Now, if your lordship will kindly come to page 36.
Hmm.
The awarding modality. Because they say they have a justified rate. So I need to point this awarding modality, clause 14. I'm just reading, lordship.
Yes.
The tender shall.
Regulated L1, L2 competence and joint director procedure. Yes.
Let me just place it.
Yes,
Let me
yes.
just place it.
I have read it, it's okay.
For my satisfaction, let me just place it.
Why you are satisfaction? I have understood why you are trying.
Yes,
to
your
frustrate
lordship.
me
I'm
on-
grateful, lordship. I'm
Please.
grateful. Then
Yes.
if your lordship will come to page 38,
Hmm. You, how
Clause
many
with-
pages you have?
lordship,
How many pages you have here in the writ petition?
writ petition,
How many pages?
116 pages, lordship.
Then
But I'll not place
160, one
everything.
after another, if you started
No,
referring,
No, if I don't
if
place
you
the clause,
referring to this pages, 115 pages.
I'm not
it will
doing
take
that, Lordship.
months together.
I'm not doing that,
Please,
lordship.
be brief, sir.
No, I'll have to place the clause.
Please,
Otherwise, how?
be brief.
Clause 20,
I have
lordship.
read your, yes,
Clause 20, page 38, clause 20.
yes.
This tender shall be governed by clause 20.4.3 under section 20 of the CPWD manual for reasonability and competitiveness rate. The next line, reasonability of rate shall primarily be assessed on the basis of justified analysis of rate prepared by the department, and accordingly L1, L2 and L3 bidders shall be finalized. So what they're saying is the assessment will be done based on the justified analysis of rates. So they have a justified rates. Now I will directly take your lordships to the evaluation process. Technically, I have been qualified along with
What
another
issue?
firm.
Come to the financial.
Yes, page 113.
Yes.
Now, lordship will see what has happened. The NIT amount, as the lordship has seen, 11 crores 25. Department justified rate, what they have justified rate is 10 crores 54 lakhs. Now, the findings and the recommendations below. After thorough evaluation of financial bid of the above mentioned technically qualified bidders, based on a departmental justified amount approved by the technical accepting committee for rupees 10 crores 54 lakhs and odd, i.e. below 6.28 of the BOQ amount, the committee found that MS North India Engineering has quoted rupees 50 crore 53 lakh 63,331.59, which is the nearest to the department justified amount within the acceptable limits, with variation of below 0.083 of the justified rate, and MS Mepung Enterprise, which is the second nearest to the departmental justified amount of 10 crores 55 lakhs 46,000 and odd, with variation above 0.888 justified rate of their respective bids. Therefore, in view of the above, the tender opening committee recommends the award of the tender to MS North India Engineering as L1 firm at their quoted rate, being the most eligible and the reasonable bidding firm on the nearest to the justified rate as approved by the department, and MS Mepung Enterprise as L2 firm respectively for issue of the LOI. Now, if your lordship will see the comparative statement at page 115.
Yes.
Lordship will see serial number 3, the justified rate. Now, who has done the justified rate? I'm just placing that, lordship. Percentage of justified rate approved by the joint director RE below to the BOQ amount, that is 6.28%. There are two amounts, lordship has seen. The BOQ amount is 11 crores 25. Departmental justified amount is 10 crores 54. And this justified rate has been approved by the joint director RE below the BOQ amount, that is 6.28. Now, considering that particular amount, lordship will see that the comparison, Northeast, the petitioner's company is 0.83%, which is the L1, and the other firm is L2 firm. Now, the justified rate has been approved by the joint director himself. And based on the justified rate, which is 10 crore 54, I happen to be the most nearest to it. From the justified, because justified rate is 10 crore 54, and I have quoted 10 crore 53. That is minus 0.083% only. So I become the most nearest to it, and therefore I became the L1. Now what has happened is, my instruction from the client is, they have given the LOI to the second bidder. Now the reason for that, when it has been asked, papers have not been submitted to us. This LOI also we have obtained on only 12th of June on by through RTI. Now the reason they are saying is that the joint director who has the authority to scrutinize the papers have found that I should not be the L1, but I should be L2. Now that finding, in my humble submission, should not be correct or cannot be correct, because the justified rate is itself approved by the joint director himself, as is evident from this comparative statement. Now, once he has justified the rates, he has found the rate. And based on that rate, I become the L1. Thereafter, on scrutiny, the same person could not have changed it, but only for extraneous considerations, it can be changed. But cannot be done in the normal course of employment. As a responsible officer, he could not have done this, because they will refer to clause 14. Clause 14 gives the power of scrutiny to the joint director. Tender evaluation committee, who is the competent authority to otherwise evaluate, has found me as L1. They have found me as L1 based on clause 20. Clause 20 says it has to be based on justified rates. The justified rate has been approved by the joint director himself, and I happen to be L1 because I am the nearest to the justified
No,
rate.
we have come across in some, they are following this, following the same procedure
Yes, Lordship.
as per what you have. That's why I said I don't want to. I've looked
No,
in
I'm
history
obliged.
also.
I did not know about
I've
that,
looked at
Lordship.
everything.
I did not know
So
about that.
they have followed certain procedure. Yesterday
So-
we have taken up 2-3 cases also.
So, Lordship, the procedure cannot be
Now
beyond what
this,
is in
it
the
appears
NIT.
that there are first district level
Yes, Lordship.
board has to
Evaluate
evaluate and then send all the, I mean, the
the
form,
papers to the joint director.
L1, L2, L3, and then
Yes.
joint director will scrutinize it.
Scrutinize.
And in all the cases, joint director found that the L1 or L2 who has been recommended by the district should be L2, L3, something like that. They have found out something, that is what I wanted to, this court wants to know. What is the basis of doing it? So unless we know, because their power has been conferred to the
For
joint director.
scrutiny only, Lordship. For
No, no,
scrutiny.
scrutiny in the
So
sense
if I
according to-
scrutiny-
no, according to them, if the on scrutiny, if it is found that the L1 become L2 and L2
the-
become L1, and then we cannot help it out.
Subject to correction, the language used is, he will first scrutiny,
Hmm,
and then if he finds it to be acceptable,
hmm,
then he will proceed.
huh.
So if he doesn't find it to be acceptable, he'll have to return it back to the tender evaluation
No, no, it's
committee,
okay, no, they can be.
because evaluation is different from scrutiny.
It's all right.
And Lordship, the other aspect of the matter, if a Lordship will see the comparative statement, who has done the justified rates, approved the justified rates? The
No,
joint
no,
director
they-
itself
They
pays 115, Lordship.
they cannot say that this justified rate approve or not approve is not correct. In calculation only, they may say that it's who is L1, L2.
Calculation has been done by them.
Hmm.
Lordship will see page 115 kindly.
I have seen.
Yes, in 115, everything is
Yes.
clear.
Yes, my lord.
Now
Same-
the joint director, how can he change this?
It is same thing, my lord. The rate quoted by the, my lord, the petitioner, my lord, is, my lord, beyond the, my lord, justified rate, my lord, which is minus 0.083, my lord,
Hmm.
page 115. my lord.
Hmm.
So it should not be beyond justified rate, my lord.
And from where is he saying this, your Lordship? May kindly ask him also. Because it says it has to be nearest. How will you decide an L1? L1 means the lowest. You have a benchmark. The benchmark is now 10 crores 54 lakhs.
Where it said this is nearest?
Here, Lordship will see the evaluation committee's report,
No, no.
findings and
It's not-
recommendations.
It's not, it's maybe wrong, because when you said it has to be within, it says 5%.
No, that
Within
5,
the variation of 5% should be,
Lordship, that then I'll just show the clause. 5% deals with the estimate. And therein it says below 5%.
no, variation of 5%.
Yes, below 5%.
If we ignore
No, Lordship, what I'm placing is below 5%, then I
Within
will have to
10%,
deposit
there must
additional
be some
performance security.
reasons.
If a Lordship will
not-
kindly
it's
see the
not
clause
that
for
there
5%. Lordship, if it is below 5% from the estimate, then I will have to deposit additional
No,
security.
that will have to deliver, we'll have to, I mean,
Lordship, clause 20,
detailed hearing is required
I
because
understand, but then,
what they are adopting is, even if you are L1,
yes,
according to them, if it is beyond 5, if there is a variation of more than 5%,
yes.
they declare the L2.
So variation.
You
has
are
to be-
L1, as
Yes.
per the estimate, the amount put to tender,
I am,
right? Number one.
yes.
They are taking simply appears to be relying on the variation of the percentage.
Then what is
So
the,
admittedly, you are L1,
then,
right?
yes.
The
If Lordship
procedure
says the
appears
estimate-
to, what they have adopted appears to be, I'm not sure, but then appears to be, see, 151,
My lord, I will
page
clarify. my lord.
150.
I will clarify, my lord. My lord, may I see page
Not
one
your
one five?
clarification.
Yes, my lord.
Yes,
Page 115, my lord.
yes.
Serial number 1, my lord. This is the tender amount.
Huh.
11 crore 25 lakhs 22,639.
Yes,
Now, my lord, justified amount, my lord.
yes.
Serial number 2, my lord. We have already deducted.
Hmm.
This is 10 crore 54 lakhs 53,252.
Yes.
This is the justified amount, my lord.
Yes.
And the percentage is at serial number 3, my lord.
Yes.
So it cannot be go beyond, my lord,
Huh?
this departmental amount. my lord.
Hmm.
No, this is the.
No, if you go beyond, if you cannot go beyond, how can you award the L2?
L2, my lord, is not minus, my lord.
Huh?
It is not beyond, my lord, this justified amount, my lord. This L1, my lord, is beyond justified amount.
How can you allow, just look at this. Your justified amount is 10,
Is 10 crore.
If we are
10 crore
considering the
54.
estimate,
Yes.
I am L1 then also.
huh?
Yes,
And the L2 has quoted 10 crore 55 lakhs.
So that way also I am
More
L1.
than the
Both side I am
your
L1.
estimate, justified amount.
And also, what is the use of justified rates then? If you are having justified rate, from there you will consider the L1. Your benchmark is a justified rate now. That is 10 crore 54. From there you will find the L1. I become the L1
No.
because I am the nearest to the
Have you
justified.
understood? What they are adapting is they're taking the percentage of variation in percentage, not the justified amount. You may be L1.
Yes.
According to them, if you, if yours is below,
yes, ma'am.
Below
or
the estimate.
more
below the
than, not the
estimate.
estimate,
Then-
justified rate,
Then I am.
percentage of justified rate.
Then it is only 0.83, Lordship.
Huh?
It's only 0.8. It's not below 5. It's only 0.83.
No,
If the
that's-
justified rate is 10 crore 54.
No,
Now, Lordship will see this. Serial number 5 of the comparative statement. Serial number 5. Lordship will kindly see this.
no, in that case, this, with the preference L2,
L2 is plus 88 and I am minus 0.83. The minus is not below 5%. It is only 0.83.
see, you are based, your claim may be right in circumstances, in the other, there's no, the dispute that you are L1.
Yes,
You
Lord.
are L1.
On both counts.
As per
If
the
your Lordship is the
justified amount.
estimate, if your Lordship
That's
is the
why I am
estimate, I must
repeating, it appears that they are taking on the basis is of the just percentage of justified rate.
Then justified rate is 10 crore 54 only. This 6.28
10
percentage is the
crore-
difference between the estimate and the justified rate.
That's
That is the difference.
The
See,
issue is, my lord,
6.28 is the
percentage,
difference.
no,
Lordship.
percentage of justified rate approved by joint director below the BOQ amount.
That is
6.28
6.28 is the difference between 1125 and 1054.
That's what I'm saying, whatever may be.
That's the difference
May
that
be
they are fighting.
difference. They are taking this basis of their decision is this percentage of justified. Whoever
So-
comes within that justified rate,
Yes. So I come within that justified rate. Because
whatever, no, yours is minus.
minus, yes, ma'am.
the nearest to the justified rate, Lordship.
Nearest, that is minus, you cannot have the more than
Lesser than the
5%.
Yes, ma'am.
That cannot be the findings in my understanding because what they are doing is they say the estimate is a rough calculation. Lordship, I have shown the rough. Then they do the justified rates. There you have a justified rate, clause 20. They say they will do it as per justified rate. Lordship will see clause 20 for a moment, page 38.
I've seen it.
Yes, it says,
Notice may be issued, my lord, in similar case, my lord,
Also
what no
notice-
origin, my lord.
Lordship, issuing of the
This
notice.
matter may be take together.
Huh?
Of same district, my lord, there, the case has been fixed after 10 days, my lord. yesterday, my lord. So,
Sagali or
Yes, my lord.
Sagali,
Of
I
Bali.
don't know, Lordship.
Balijan.
Yes, my lord.
This is Sagali.
Sagali, yes.
This were the same board.
Same, my lord, no, but for same, my lord, works, my lord, MG Nariga.
Everywhere, if the district committee, who is the evaluating committee, the competent authority,
All
finds
they-
someone L1, how can the project
they-
director
all
all
they
the
ha-
time turn the tables and find
No, that-
there
that-
something is happening inside?
All the recommendation,
How can it be turned down
in
every?
all the cases, the last 1 week I've seen is all the recommendation of the district committee has been
Rejected.
rejected, turned down. They have their own kind of procedures. Would like to see. That's why we have not fixed it.
7-member committee,
For a
competent
long
authority.
time. One matter I fixed it after a week,
Okay.
and this district, I think, Papumpare,
Yes, Mahumpare, yes.
Lordship,
Sagali or Balijan block, I
Balijan.
fixed it
Lordship
after
will
10.
definitely have
Will-
their,
will-
Lordship will definitely have their records. But then why I am arguing today is because
Oh, I have
to
understood.
protect the subject matter of the
Okay, we'll
litigation.
issue notice.
Yes.
You take justice service. We'll take up this matter with that, along with that matter.
Along with, yes.
Same procedure.
Yes, ma'am.
The district board recommends
And they
and
reject.
these what do you call it?
Joint director.
Joint director.
Directorate level,
Yes.
it is all rejected.
Yes, ma'am.
They are issued the LOI to all other third or L1, L2 or L3.
Then what is the use of this evaluation
That's what-
committee then?
But one thing you also remember, even if you are L1,
I
it
understand.
doesn't mean that you'll
No,
be.
I am L1 nearest to the justified rate. That is my argument. Because clause 20 says it is based on the justified rates. So if you have a justified rate, because estimate is
We'll
rough.
take it up on along with
Along with this
remember
one.
that thing.
Yes, my lord, this is,
Lordship will-
We'll decide it. Let me see.
Did-
Let
let
us
me
see.
dis-
Let them
I'm
file
obliged
the
for it.
response.
But Lordship will protect the subject matter of litigation.
No,
It's supply matter, Lordship.
we'll say that
This is
will be
supply.
subject to outcome.
But then this is
No,
supply,
if we
Lordship.
found that we'll set aside.
Then if the supply already takes place, matters become infructuous. The very subject matter
Cannot
frustrates.
help it.
public interest has to be seen.
No, public, in the name of public interest, they cannot keep on doing illegalities at all point of time.
29 May. No, they will not be able to supply. Huge amount.
I
Even
do
if
not know,
supply.
but I do not know. But then my anxiety would be to protect the subject matter of the litigation. Tomorrow the matter should not become infructuous. So therefore I'm praying, let them not sign the contract at least.
Challenging the letter of intent dated 29/05/2025.
Received on 12/6 lawsuit by RTI.
Issued by the-
Below lawsuit will see.
Director, Rural Development Department, in favor of respondent number, in favor of one MS
5 lawsuit.
Message Mefung Enterprises, comma, respondent here, respondent number 5.
Number
hearing,
5 lawsuit.
comma, respondent number 5,
Yes, lawsuit.
5.
Five.
Comma, and by rejecting the bit of the, no, rejecting the tender of the petitioner, although declared as L1 by the Tender Evaluation Board, District Tender Evaluation Board, and as recommended, comma, as well as challenging the proceedings as adopted by the gender, what do you say there in the directorate level, directorate level in re-evaluation of
Joint director level lawsuit. He is a joint director.
then pursuant to the, what do you call? Notice inviting, NIT, pursuant to
NIT.
the NIT.
31st March 2025. 31st March.
31/03/2025
For supply of material under MZ and Regas Saga.
pertains to the
Page 23 or 19 lawsuit.
supply of what?
Supply of materials
Materials
under MZ and Rega
under MG Nrega
25-26
25/26
in respect of Sagali
in
CD block.
respect of package
Sagali.
6 CD block
Yes,
Sagali
lawsuit.
in the district of Papunkari. This writ petition has been instituted. Mr. A. Sharma, learned counsel for the petitioner. While referring to the documents, including the SBD, provisions in the SBG. As well as the comparative statements and the recommendation submits that admittedly the petitioner has been declared as L1 as the petitioner has quoted rupees 10, 53, 63, page 115, huh? Petitioner is not in the engineering, huh? Which is nearest to the justified amount as well as justified rate as approved by the department. Whereas the respondent number 5 has quoted rupees 10, 5, so and so, so and so. You keep the below here also below minus 8.7% and above 150. Therefore, the rejection of the petitioner acceptance and consequential issuance of LOI to the respondent 5 is totally illegal and arbitrary. Issue notice returnable within 10 days.
And then
Mr.
some matters are fixed after 10 days. Let it come along with those matters then.
Mr. B. Pitcher, London Standing Council or the Rural Development Department enters appearance accepts notice on behalf of
1 to 4.
for respondent number 1 to 4. No formal notice. However, so and so, huh? Mr. In view of the next paragraph. Next and then Mr. So and so learned constable petition to take steps for service of notice upon
By Dusty lawsuit.
respondent number 5 by Dusty Mott within 2 days
Yes, laws.
from today. Considering that the similar matters is fixed,
Read petition 267 of 25.
similar matters being WPC
267
67 of
25.
2025 is fixed after 10 days. Let this matter be listed along with the WPC so huh?
So in the interim, lawsuit will protect the.
Mr. B. Pitcher, understanding will shall file the response honored before the next date of listing and place the records. Huh?
Yes, sir.
Mr. Having next paragraph, consider the submissions and on perusal of the recommendation and the evaluation report, evaluation report and the report, recommendation of the district scrutiny district
Evaluation.
board, comma. The award of supply,
Yes, lawsuit. LOI, lawsuit. LOI.
the issuance of
Supply order.
supply orders to the respondent
Number
number
5.
5 shall be subject to outcome of this request.
Lawsuit would have said,
No, same
Let us
order
go.
way passed. All right.
I'm obliged, lawsuit. I'm obliged.
Heard Mr. T almost so and so, so and so, so and so. Huh? That
Yes.
item, yesterday's item,
Yesterday's
Read
item, my
petition.
lord, it is W
you are
268.
L1,
Yes, L1.
L1.
My lord, I have a different ground here. My
No.
lord, I'm challenging my
I'm in your
reject.
ground.
268, WPC 268.
268, same order. In that case, in place of L1 should be L1. In place
He
of
is claiming
L2,
L1.
L2, huh?
He is claiming L1.
Yes. In place of that, in that
L2.
petition L1, it should be L1, L2, huh? In that petition, it was L1, L2. Here, L1. name Tiomo, huh? So and so, same.
Same.
After a week, list along with so and so, same order. Hmm.
Obliged.
My lord, by impugn order dated 11/6/2025, lordship will find that page 56, my lord. There is a direction is given to me, my lord, my lord, in form of a notice, my lord, not to further carry out, my lord, any business, my lord, trading activities.
50? 56,
56, my lord.
yes.
May I read, my lord? Whereas a joint inspection was carried out on 22/4/2025 with town magistrate and officials of this office, and it has come to notice of the undersigned that you are carrying out trading activities without obtaining a valid trading license from the competent authority, and whereas the conduct of such commercial activity in absence of requisite authorization constitute a violation of the trade regulatory provisions in the force. Therefore, you are directed to immediately cease all trading activities in the premises within 7 days from the date of this notice. Non-compliance with this direction shall attract further necessary action as deemed fit under law without any further notice. If you believe there is a valid legal claim to conduct trade from the said premises, documentary proof substantiating the claim must be submitted to the undersigned within 7 days from the date of this notice, my lord. And accordingly, we have submitted one representation, my lord. My lord, crux of this case is that, my lord, the petitioners, my lord, three Gumtis, my lord, standing, my lord, in a, my lord, 21 square feet meter, my lord. That land was, my lord, in possession of the petitioner since 2000, my lord, and petitioner has applied for the allotment of the land in proper format, my lord. And accordingly, my lord, land was verified, my lord. For a moment, my lord, kindly see the, my lord, verification report at page,
It's okay, we'll issue notice.
my lord.
But admittedly, you have no allotment, no license.
That was the
you
reason,
can
my
be
lord,
allowed to
for
run
not
the-
extending my lord trading license, my lord.
Hmm.
It's an indirect way to evict me from the.
Do you have the
present site.
trading license?
My lord, till
See,
2015,
unless you have the allotment
my lord.
for business purpose,
Yes,
you cannot be issued trading license.
my lord.
Even if, assuming even if you have no allotment for to have a trade or something like that, to do business, you will have to have a trading license.
Yes, my lord.
Otherwise, it will
My lord,
violate the trade
My
regulation.
said land, my lord, which was, my lord,
Do you have the trading license?
yes, I was having the trading license.
Not
Till-
presently.
No, my lord. 2000, up to 2016, my lord. Now there, my lord, try to, my lord, evict me, my lord.
Hmm.
There was a process
Obviously,
for,
you don't have the allotment order.
I will come to that, my lord.
Yes.
My lord, they have tried to, my lord, there is a process initiated to evict me. Lordship will kindly see at page, my lord, 41, my lord.
Yes.
There is a process to evict me, my lord, at page 41, my lord. My lord, may I read this from type copy is there, my lord, but I will try to read out from this page 41, my lord. Just I will read out,
If
my
you
lord.
have the type copy, let us.
Because, my lord, we have not typed properly in the type copy, my lord. Last program, there are altogether, my lord, 9 persons, my lord, who were, my lord, supposed to be evicted on, my lord, 31/1/1996, 2006, my lord. And, my lord,
Type
la-
copy is page 43.
page 43, my lord, yes.
Have some mercy on this court
And
because
Yes,
of the
yes.
poor
May I
problem
read,
with
my
the
lord?
poor
In
eyes.
continuance to this office dated 7/1/2006, the following occupants of the Gumtis Old Delhi Market along are hereby directed to dismantle the existing structure by themselves in view of serious allegations launched by all Alo Local Women Marketers Union on 7/1/2006 and also on directed by the government on or before 31/1/6, following which eviction drive shall be carried out on 1/2/2006 by the state officer. These are the 9 persons, my lord. My name appears in serial number 1, my lord. Last paragraph, my lord. Though there is no mandatory provisions to allow aforesaid occupants alternative plots, since they were not formally allotted the government land at present eligible, my lord, it is a present site, my lord. However, on the humanitarian ground, the eligible, my lord, it should be Dalab, my lord, District Land Allotment Advisory Board, my lord. In sitting on 13/1/2006, had decided, my lord, not directed, my lord, to recommend, my lord, alternative plots for the allotment of adjacent to opposite side of the Mima Cinema Hall and other areas near ALG along, my lord. Pursuant to this, my lord, recommendation of the Dalab, my lord, altogether, my lord, 11 persons were recommended, my lord, so you'll find at page 47, my lord. Excluding me, my lord. There were altogether 9 persons to be, my lord, evicted, my lord. However, the Dalab considered, my lord, for an alternative plot, and accordingly, my lord, the 11 persons were given alternative plot, my lord, excluding me, my lord, and added, my lord, 3 new persons, my lord. In the, my lord, near Alo, my lord, airfield, my lord. Thereafter, my lord, I have again approached this, my lord, approached the deputy commissioner at page 48, my lord. Saying that, my lord, my case has not been considered in terms of the recommendation made by the Dalab, my lord.
Because there was not, as per the law, it was only on humanitarian.
Yes, yes, my lord. But, my lord, other persons were given, my lord. And, my lord, this matter came up, my lord, again on, my lord. Lords, you will find at page 54, my lord. Now, nearby area, my lord, in the earlier, my lord, garage, my lord, of the PWD, my lord, there the urban department is constructing parking place, my lord, leaving 20 meters from all the 4 corners, my lord, 4 sides, my lord. Now, circular dated 5/2025, my lord, page 54, my lord. This is to inform all the concerned that a meeting has been scheduled to discuss matters related to shifting of Gumti line adjacent to previous bill counter of power department Alo at All Market under Urban Development UD on 6/5/2025 at such and such. All the Gumti owners and stakeholders requested to attend the meeting without fail to facilitate necessary discussion and decision, my lord. And we have, my lord, submitted all the documents, my lord, since the beginning, my lord. The proceedings, my lord, has taken place, my lord. Now they have assured, my lord, that they will be, my lord, exhaust us, my lord, by allotting, my lord, in nearby area, my lord. Then, my lord, thereafter another meeting was held without, my lord, inviting us to that meeting, my lord, at page 55, my lord. Serial number 4, for relocation of serial number 4, relocation of Gumti line located at All Market near Ladies Corner, my lord. This, my lord, we are not aware of, my lord, the minus of the, my lord, meeting, my lord. Anyway, my lord, since beginning, my lord, we are supposed to give an alternative plot, my lord, to relocate, my lord, our business plot, my lord. Then suddenly this notice has been issued, my lord. This is, my lord, in guise to, my lord.
There's no order after the application.
No, my lord.
We'll direct them to dispose of your application.
Yes, sir. Till then, my lord, no, my lord, courses measure may be taken, my lord. Because it is only my livelihood, my lord.
No, they said that if you believe that there is a valid legal claim to conduct trade from the said documentary proof substituting the claim must be submitted to the undersigned within 7 days from the date of this notice. When did you file that application?
Application, my lord, on 16, my lord. We have received the, my lord, on 13, my lord. In paragraph 1 itself, I have stated, my lord, in my representation, the notice is received on 13/6/2025, my lord. Paragraph 1, my lord. 13/6/2025, my lord.
No, which one you have received?
The notice, last impugned notice, my lord, page 56, my lord.
Okay,
Notice of 11/6/2025, my lord.
within 7 days.
My lord.
So you have filed your application on 16.
16, my lord.
Yes,
Let, my lord, the
They're not
dispose of, my
evicted.
lord.
they just simply say that all trading distributors information within this cease to operate,
Yes, my lord.
stop operating.
Yes, my lord.
And you have given
to
a
submit
chance to
documentary proof.
submit documentary proof, whatever, 7 days. You have done it.
Done.
Direct them to, you'll not be evicted unless they decide.
Yes, sir.
All right,
My lord, if a decision is made, that may be communicated to us, my lord.
obviously, we'll say that you should be heard.
My lord.
There's no question of any interim.
My lord, no coercive measures may be, my lord.
Because it clearly says to stop from operating and then until and this should be heard and they'll decide and immediately communicate.
Say in disguise to my lord, evict me, my lord, basically.
Maybe. But then we'll have to go by the language and the tone and tenor of the
My lord,
order.
yes, my lord. No, my lord,
We
this may be disposed along
we
with the,
just
my
cannot
lord.
go what's cooking behind.
My lord may kindly observe, my lord, the page 54 circular, my lord.
Ah.
Whereby, my lord, a proposal was made for reallocating me, my page 54, my lord.
It is info all concerned. The meeting has been scheduled to discuss matters to the shifting of the Gumti land. Requested to attend the meeting would have failed to.
Because in terms of this, my lord, no final order has been passed, my lord.
A mid-review meeting is scheduled with the officers usually and all of so. Yes. Heard Mr. Arsoike learned counsel for the petitioner. And also heard MS T. Wang learned additional learned state counsel for all the respondents.
Yes, ma'am.
For all the respondents listed. Considering no, the challenge made in this writ petition is to the notice dated 11/06/2025 issued by the Deputy Commissioner West Siang District, Alo, whereby the petitioner has been directed to immediately stop all trading activities in the premises within 7 days from the date of the notice. List of and to submit any documentary proof if the petitioner is having a valid claim to conduct trade in the premises. List of having considered the next para, nature of grievance raised in this writ petition, and as agreed to well and counsel for the parties, this writ petition is.
My lord, I am sorry, my lord.
Petition is
My lord,
heard and
the
disposed
writ
of.
petition may not be disposed of, my lord, because there are another two prayers, my lord, regarding the regulation of the land and the allotment of alternative plot, my lord. At this stage, my lord, only the representation may be disposed of, my lord, regarding the
Then
trading
in that
license.
case, you will just issue a notice.
In the meantime, they may dispose of the representation, my lord. This is regarding the trading license, my lord.
No, if you issue a notice, we'll simply say that it should not be barred to dispose of your representation. If we issue a notice.
My lord,
Anyway, in that case, forget it. Then in that case, heard Mr. So-and-so. And then the challenge made so-and-so, that will remain. Then issue notice, returnable by 3 weeks. As MS so-and-so, T. Wang Molan, State Council, enters and accepts notice on behalf of all the respondents. No formal notice need be sent by so-and-so. Next para, having considered the submissions of land counsel for the petitioner, as well as considering that the considering that the petitioner is a small businessman Small, petty
Small.
businessman,
A PT business.
running,
Gumti, my lord, three Gumtis.
Gumtis on a trade license, with a trade license issued way back in 2006.
No, yes, my lord.
Temporary trade license. way
2006
back in
only.
2006. And at one point in time, the case of the petitioner, the case of case of the petitioner with regard to allotment of the land in there. Where is that over the
Page-
allotment of the land
Page 41, my lord.
measuring 21 square meter, huh?
My lord.
21 square
21,
meter.
my lord.
On at where?
Near, my lord,
Near
electric PWD garage, my lord, opposite.
PWD, electric oblique PWD garage, opposite ALG,
ALG, allow, my lord.
Alo. And as well as considering that the discussion with regard to shifting of said Gumtis, including the Gumtis of the petitioner, till the next determinable date. In the interim it is provided that no coercive action may be initiated.
Okay.
The pendency of the writ petition shall not be a bar to dispose of the application dated 16/6/2025 filed by the Deputy Commissioner. Why you have filed before the circle officer?
My lord, he is the authority, my lord, for issuing of the, my lord, trading license now, my lord.
Before the circle officer. TNC.
Trade and Commerce, my lord.
57, huh? Alo, West Siang District. Please, the petitioner is also liberty to file an application before the Deputy Commissioner. Within 7 days. No, to file representation before the Deputy Commissioner, West Siang District, Alo, for consideration as indicated in the notice dated 11/6/2025.
Oh,
You have not filed before the appropriate authority.
no.
Should have been before the Deputy Commissioner.
Obviously.
Lordship,
Yes,
in this matter, Lordship, this is with regard to land matter.
yes.
This, I'm claiming that this preliminary notification is,
Heard Mr. T. Tapak, London Council for the petitioners.
petitioners.
Where is the notification?
Kindly see page number 34. 34 is there and 30, annexure, yes, annexure 2 and 3. 32 and 34. Type copy is 33 and 35 is type copy,
It has already been acquired.
not acquired. This is mechanical. Mechanical, I mean,
But
this,
still it remains.
no, nobody has received any land compensation. That's short. That is the issue here. And as
How
per
many
the,
petitioners are here?
only 10.
The next para. The petitioner, 10 in numbers, claiming to be the,
Yes,
he claims to be the
land owners,
land
owner
owners of what?
of a Kaing Army Camp.
How many areas?
Area is, my area, there is actually 131, as per the claim, it is 131. I am claiming only 71 acres,
Huh?
71 acres,
Measuring around 71
acres.
acres, which is under the occupation of the what army?
This is, now it is Indian Army,
Indian Army
yes.
at Kaing in the district of Siang. Has spread for the direction for payment of land compensation under the right to fair compensation and transparency in land acquisition, rehabilitation, resettlement Act 2013. As the acquisition proceedings initiated under the Land Acquisition Act 1894 have lapsed. Christopher, the petitioner further, petitioners have also challenged the notification dated 15/06/1983. No, preliminary notification dated 24/09/1982 and notification dated 15/06/1983 under section 4 and 5 of the Land Acquisition Act 1894. Issue notice returnable by 4 weeks.
6 weeks.
Huh?
6 weeks, since
6
they will,
weeks.
yes, they will require.
6 weeks. 8 weeks. Or 10
6
weeks.
weeks will do.
10
8
weeks.
will- Because central government is there and it will communication, it will require time.
6 weeks.
6 weeks.
Is Mr. Which one?
Is from respondent number.
I'm from respondent number 1, 2, 3, and 4, my lord.
4.
Since as Mr. M. Katur learned DSGA and MSG at learned additional senior government advocate entered appearance and accept notice on behalf of all the respondents. No form.
5,
Ah.
6, 7, 8.
All the respondents,
Yes, all the respondent.
no formal notice need be served, issued. No formal notice need be served, have extra copies signed.
All right.
Lordship, this writ petition, Lordship, I have challenged the order of arbitration board, whereby they have passed this order despite knowing the fact that in the same issue, there is a CRP, civil revision petition pending before this honorable court, which is take up with this writ petition today.
There was an order of the dispose restraining it.
Yes, Lordship, there is
Huh?
a stay order from this honorable court in the
Then-
CRP.
Then
Lordship, in spite of knowing this fact, this judgment and order has been passed by the arbitration. So why I have been aggrieved and I have challenged this in this writ petition.
service report. Who is respondent number 3?
Respondent number 3, Lordship, by order dated 27/6.
Yes. So what is the order? Where is the order?
Order of.
Impugn order.
Impugn order, Lordship, at page 25, Lordship. Annexure 5,
Page
25. In fact, this judgment and order is also an ex parte order, Lordship. In absence of me, this order has been passed, Lordship. In the third paragraph also, Lordship will peruse, Lordship, that they have in fact noted that this, in the same issue, the matter is pending before the High Court.
Is noted.
Yes, Lordship, they have
Where it is? Where it is?
paragraph 3 of the judgment, Lordship, page
Ah.
25. Upon the known presence of the complainant party, the undersigned has sent an order addressed to the Pakjan Puchung, GB Hiri, to present and produce the orders issued from the Honorable High Court, Itanagar Permanent Bench, with regard to this particular land on 23/9/2022 at around 9:30 AM. Without fail, the said order has been communicated to Sri Pakjan Puchung on so and so through a special dark runner, but once again has failed to attend the said hearing. Now,
Yes, you would have produced it easily.
Lordship, before this passing of this order, Lordship, immediately when this committee was constituted, Lordship may kindly come to page 22, Lordship, 22 and 23. Now, Lordship may come just before that, Lordship, page 21. Through this order, page 20, annexed 2, Lordship. Through this order, this committee was constituted for settlement of the particular dispute. Now, after knowing about the constitution of the committee, page 22, Lordship, I have immediately written to the ADC regarding the pendency of the matter before his honorable court. Now, page 23, may kindly come to page 23. Lordship will find that, in fact, the circle officer on behalf of the ADC has clearly written to the chairman. the
What is
committee-
CRP? CRP challenging this
This
interpret the decision passed by Additional Deputy Commissioner. Huh? Mechuka. People court has decided. This decision, what is the challenge in CRP?
same area, same lane, Lordship.
No, not the
Hello.
question of order of which decision.
In the CRP, they have challenged the order of the ADC, Lordship.
That is
Being the appellate or-
ADC, that is 1312.
13
1312 2017.
13/12/2018 and 14 April 2018, Lordship.
Huh? What is 1412?
14/12 is an order of the ADC whereby he has constituted one arbitration board, Lordship. That has been stated, Lordship. This very order has been stated in the CRP. Lordship. That order I have annexed, Lordship.
Where it is?
Lordship, in my writ petition, Lordship, I have annexed that. At page, starting from page 18, Lordship, at operating portion is at page 20, Lordship. Considering the entirety of the matter until further order, the impugn order dated so and so 4/4/2018 issued by the additional deputy commissioner is hereby stated. Lordship, since there is a stay of this order, now this, how could they, Lordship?
What is 1312/18 is what?
Pardon?
13/12/2018.
Thirteen 12 is another order of the ADC, Lordship. Whereby the ADC has asked to submit the list of the
Has
arbitrators,
referred the matter to arbitration.
Lordship. In that order, the ADC has sought for submission of the list of the arbitrators from both the parties. If Lordship is taking up the CRP, Lordship will find that at Annexure 6, that order, Lordship will find at Annexure 6. Now, in my writ petition, Lordship, my contention is the same dispute, same area, same lane, Lordship, the dispute is pending before this honorable court in the form of this civil division petition, and there is a stay from this honorable court. How can they, Lordship, they come up with this judgment or order by another arbitration board, Lordship?
You
That is
have
my judge.
asked to produce the court's order. You have not. You could have produced it easily.
Lordship, I have in fact written it written to the ADC, Lordship. On that day, I could not be present because of my illness, Lordship.
All these are, you could have produced it. You have written and you have placed the
Lordship,
order of the
to
court.
ADC, I have clearly I have submitted, Lordship. Lordship will kindly come to page 23, Lordship. Now, acknowledging my application, the ADC also has written to the chairman of that particular arbitration board to stop the proceedings in regards to this particular dispute, Lordship. Lordship may kindly take up
Then,
page 23.
huh?
Page 23, Lordship.
No, then how he has decided again?
So why, Lordship, that is my ground of challenge, Lordship. How could they, in spite of knowing all these facts, how could they
No,
go
it's
ahead
not a
with this
question of facts.
settling the dispute, Lordship?
The issue of, I mean, who has passed this order, impugn order?
Lordship, the arbitration board that was constituted, Lordship,
Huh.
by the ADC, Lordship.
Hmm.
Now, in fact, the ADC, he himself has written to the board member, page 23, down below, Lordship. Lordship will see a note from the circle officer.
And then this is cover decision.
Page 23 of
Ah.
my writ petition, Lordship.
No, page 25, annexure, it's a cover decision.
Yes.
Huh?
Lordship will come to page 27, last page, Lordship.
Hmm.
Lordship will see arbitration board members, Lordship. Member, umpire, arbitration board member, Lordship. Lordship will see that, Lordship. Lordship may kindly come to page 24 also, annexure 4, Lordship. Lordship will see that this arbitration, through this order, that arbitration board was constituted, Lordship.
Twenty?
4, Lordship.
Hmm.
Now here, Lordship, the Singluk Koje, who was appointed as the umpire, by order dated 11 August 2020, Lordship will find at page 21.
See, though it is used the word arbitration, it is not as per the, not in terms of the
AFR, Lordship.
AFR 38.
Lordship, that is one of my challenge, Lordship.
No, but then the decision, the administration wants that it has to be decided by village authority, that's all.
Lordship, this
It's
committee,
a, the committee has constituted.
Lordship,
If arbitration proceeding has to be taken place, what is the procedure?
Lordship,
Equal
Procedure,
numbers of
Lordship.
arbitrators will be allowed to nominate
Lordship, yes.
from both sides. That is
Lordship.
not been done. It
No.
simply says arbitration. Word used has been arbitration, but then it appears to be a purely cover decision. If it's a cover decision, you file an appeal. I
Lordship,
understand that cover ought not to have decided. There is a pendency, but it would not like.
Lordship, may kindly come to page
You
21
file
also.
an appeal, we'll give you a liberty to file an appeal. You may take that ground also before the appellate authority.
Lordship, may kindly appreciate, Lordship, page 21 also, Lordship.
So-
Page 21, the committee that was constituted,
Hmm.
that the lane falls under the dispute. Since the transnational highway was passing through that lane,
Hmm.
so why that disputed arose, Lordship.
Ah.
Now, this committee was constituted to settle all the lanes dispute pertaining to that area which is falling through the
Are you
trans
challenging
highway
that?
area.
Are you challenging the
Now,
constitution?
that is also one of the ground that this committee that was constituted, can they decide the titles?
No, this is by
Title
the
dispute,
village,
Lord.
this is by the village authority. Head Gaburas were there.
Lordship, they are not, the chairman, he's not a Gambura, Lordship. He's
Hmm.
he's an ex-ASM, Lordship. So how can he decide, Lordship?
Anyway, that is-
Now that
But also-
order,
but-
subsequent
but
order, that is also
it
being.
is in actually it is a Kaba decision.
Lordship, cannot be said as a Kaba decision, Lordship.
How the Kaba decide? It's not only the Gabura will be there, they will decide, but the other non-Gabura members will also be there.
Lordship, of course, they were there, but but then the way the members were.
This will
was-
give you a liberty to file, to avail the appropriate remedy. Writ petition. Come to CRP.
My lord, sorry for interrupting, my lord.
CRP, I'm not appearing, Lordship.
Then how you are aggrieved?
Lordship, this very lane which has been decided in the order which has been impugned, that very dispute lane is subject matter of adjudication in the CRP, Lordship.
Then who you are? Are you not the party in CRP?
Lordship, I am there, Lordship, but Sansar is representing that
Okay,
matter.
so I'm.
I am not the council.
So that's why. So I'm dismissing this. Writ petition dismissed.
My lord, one of the most important thing is that it is a matter of 2018 because that was
No, sir,
When the-
sir, we're yet to come to your petition, CRP.
CRP is where my learned friend Mr. Rintu has filed CRPC.
Yes. Heard, Mr. Who is for respondent?
In my case, Lordship,
Yes.
state in there is private respondent also,
Who
Lordship.
is private respondent?
Lordship,
Three, my lord, three.
he has not.
Three.
Huh?
I am representing.
Sir, how can you? No, how can you appear against him and this petition and the CRP for others?
But my lord, we are not in the writ petition.
He's not.
As a respondent number 3,
Who is
private respondent.
Lordship, in my writ petition, Lordship, respondent number 3, no one is appearing, Lordship.
He
Service
said
is
respondent
completed.
Number 3.
No, Lordship. In the writ petition, no one is appearing, Lordship.
He said respondent number 3.
Respondent number 3, my lord.
Writ petition.
Yeah.
Who is respondent number 3?
Lordship, Lordship may
Tame
kindly.
Popor.
And in CRP?
I am for the.
They are also.
Sir.
They are also.
That is conflict, totally conflict, sir.
No, it is
Total
the-
conflict.
Lordship may kindly take up writ petition, Lordship, order
I-
dated
I-
27/06/2027.
I refrain from making any comment, much less passing any order. Please
Okay.
think about it. It's very serious.
Yes.
Sir, you are senior law.
No,
One
my
of the
lord,
senior
my lord, we have not
senior-
filed writ petition. It
But
is
he has
filed
not
by.
filed power also, Lordship. He has not filed wakalatnama also.
No, he said he's appearing.
I don't know. Today only I'm coming to know that he is appearing, Lordship.
Are you
Otherwise,
appearing
Lordship-
for respondent number 3 in writ petition?
Yes.
And in CRP?
CRP also.
CRP is
Because same party there.
in CRP, you are appearing on behalf of the petitioner.
No, no,
Who is
no,
a respondent? Who is a respondent?
They are also respondent.
Work it out.
He might be confused, madam.
Ah,
He might be confused, madam. In fact, he is appearing as a respondent in item number 6 CRP.
CRP, huh? Then
In the writ petition,
who are the petitioner, CRP, respondent in CRP?
this is the writ petitioner in item number 5.
Okay. That's what I'm saying. If he appears for the petitioner and the same persons who is responding in CRP, he cannot appear against anybody against the writ petitioner.
Yes.
So you are appearing, the persons who have filed the writ petitions are the respondent in CRP.
Yes, madam.
So you are appearing on behalf of the respondent.
Yes,
Now, the same person filed a writ petition.
as a respondent number 3.
No,
No.
as a respondent, as a petitioner. So you are appearing on behalf, you are appearing against those, your own, the same persons in the writ petition. Because you said you are appearing for respondent number 3.
3 years.
Respondent number 3 is also respondent in the.
No,
CRP.
He's the petitioner, Lordship.
He is the petitioner.
Yes. Yes, he's the petitioner, Lordship.
At 2, kindly reflect yourself, sir.
Lordship, may I clarify
It's
one thing?
very
Lordship?
serious. You cannot do this.
Lordship, may I clarify one thing,
Yes.
Lordship? In the writ petition, he has not filed, even if he's submitting that, he is
Forget about
appearing.
that. He said, that's why I'm just giving him to
Okay.
reflect himself. But the facts remain that the petitioners, the person whom he is representing in CRP is the petitioner.
CRP,
The persons
yes, Lordship, he is
whom he is representing in CRP as a respondent are the persons who have filed this writ petition
Right, correct.
by you,
Correct.
right?
Correct.
And in your writ petition, he is appearing against the same persons whom he is representing. Sir, are you sure? Are you have been authorized to appear in as a respondent number 3 in writ petition?
Yes, madam.
That is the problem. Kindly
Let me check.
have some deliberation
Yes.
among yourself.
All right, Lordship.
I don't want to, comment anything.
Lordship, at 2?
At 2, please. Because
Problem.
at this stage, I don't want
Yes,
to,
we should not
like it.
confuse about
Yes,
the
yes.
legal matters.
kindly.
Right.
My lord, the writ petitioner hearing, my lord, wisdom, my lord, honor of some land.
Yes,
Yes, may your lordship, here your lordship, we have not received the Paravas comment your lordship for filing our counter affidavit.
My lord, so far this case is concerned, my lord, affidavit may not be required because, my lord, my claim is that since my land has been acquired by the government and as per the government on notification, the deputy commissioner was supposed to acquire and reassess the compensation under the new act of 2013. There's the government specific
sir, you are
notification.
not the only person.
My-
Our road is completed now.
my-
You have received the
No,
amount.
not taken.
You have not.
Not.
You have not accepted.
Not. Now the chief secretary, because earlier round of litigation, since they were not responding my legal notice, then in the first round of litigation, direction was passed by this honorable court, directing the chief secretary to consider my grievances. Then pursuant thereto, then interim order has been passed by the chief secretary saying that I am not entitled under the new act, but under the June land cultivation. This is one ground. Another ground is that there is a discrepancy in the assessment event. Because when they were making assessment, because I raised those issues, so far my rubber samplings are there that they have not properly assessed the standing rubbers. That's one issue. Another ground, my lord, that discrimination has been done because in the same location for another similar project, my lord, and the respondents are the same, everything are the same. Land rate is differently paid, my lord. For plant and rubber, different rate has been paid, my lord. But so far, my case is concerned.
Who else are doing, having the rubber plantation?
My lord.
Your father, you and your father.
So far, my lord, father part is different, my lord. Now this is for me only. But now, my lord, at this stage, my lord, my only,
Claiming
my lord,
anything with your
my
father.
lord, at this stage, my lord, similar order has been passed in respect of same project, whereby this honorable court has directed that assessment has to and calculation of amount has to be done.
In other writ petition.
Yes, my lord.
Yes.
Yes.
Have you annexed it? Where is it?
Yes, my lord. May I
Yes,
check,
yes,
my lord,
yes,
to
yes.
page number 145, my lord?
145.
145.
My lord. Basically, it starts from page number 138 basically starts, my lord. This is in respect of the same project.
Yes, no, I cannot.
My lord. Then my lord,
If
this
you are claiming this, you are relying on this.
no, my lord, this judgment, my lord,
110.
no, my lord, page 138, my lord.
What is 110?
100, my lord, this is the one decision by the division bench, my lord, in the read appeal, whereby, my lord, it has been held that
This court, well, in that side, have lost,
my lord,
badly lost.
my lord, my lord. My lord, pursuant thereto, my lord, this page number 138, my lord, annexure 14, my lord. This order was passed, my lord. 138, my lord. Same project, my lord.
That in that case, if you are relying on this, I cannot be a party to pass this. May not be proper.
Otherwise,
On
also,
a lighter note, I said I have badly lost it. At the same time, I was a part of all this decision. So since you are relying on this, it should not be before me. What do you say? Yes, sir. I think I should not take up this matter because since he is relying on this. But then this order has been, I think, it has been stayed. It is stayed by the Supreme Court.
but
It's
my
still-
case,
still
my lord,
pending.
my case slightly different, my lord, because, my lord,
Will be, if it's,
my case is, my lord,
will be, sir, whatever. If you are relying on this judgment, I think I should not take up the matter.
my lord, then it can be, my lord.
We'll say before after any other appropriate point. List this matter.
May I pray for a specific date, my lord, after?
No, if it is not before
Oh,
this
man.
bench, list this matter before any other appropriate bench without me.
Deeply ordered. Item number 9 to 20 are similar matters filed by my friend Devri, and 21 is by my uncle. So 9 and 21 can be taken together. Because there are two affidavits of the government there, but variation is there.
9 in?
9 and 21.
Yes.
So both
By
these matters-
both of them.
Yes.
9
From
is by
9 to
you.
20,
Huh?
21, I'm afraid.
Huh?
21 he is appearing, and
And-
9 to 20, my friend Mr. Devri is appearing.
You are
I'm
for
for
9 to 21.
20.
20. And?
And he is for 21. I am for the respondent, private respondent, Oil India Limited. This is regarding that oil exploration, crude oil exploration issue, where there is a interim order now.
So you said where is the difference? From 1 to 20,
1 to 20,
similar,
same
area,
area,
same area.
and 21 is a different area, Modokka Nala, and that is a different. These are some point.
Only
And-
the areas are different.
And two affidavits by the forest department has been filed in both the cases. With bit variations are there. So therefore, those two matters will be looked into. Others,
Then say,
10 to 20 are therefore similar matters. 10 to 20, 9 and
is
20.
up to, huh? Huh?
Issue will remain.
Issue will remain otherwise same.
Huh.
Areas are different.
Yes, so this 9 and 21 are Maduka.
No,
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 Sum
9
point
to
two.
20.
9 to 20,
Modokka.
No, no,
Modokka,
Sumpoi two.
Sampoi.
Sumpoi two.
Sumpoi. And,
21 is Modokka.
21 is Modokka.
okay, so two cases.
Two cases, actually two cases. That's what I'm saying.
Different-
So 9 and 21.
Issues
can
are
be taken.
same, but different areas.
Areas are different. So
Different location.
different location.
Yes,
Your Honor, here I'm filing
which one?
9, item number 9 to 20.
9. Item 9.
9.
Yes.
This is the case with regard to the eviction notice which was issued to me.
Hmm?
My village is a surveyed village, Your Honor. It was, the land was, a SITA registered was prepared by the government of Arunachal Pradesh way back in 1979. Before the notification was issued declaring the area as an Anchal Reserve Forest in 1982. So that I annexed as Annexure 10 in page number 30.
Annexure 10,
10, page 30,
page 30.
30. This is a Sita for survey village, village Sumpoi Deori.
Tumpoi.
Yes, Sumpoi Deori. Moja Kangam, Circle Dayuns, District Tirap, Arunachal Pradesh. Here, my father's name is there, which is mentioned in serial number 5 in page 32. Area, name, dark number, and everything is there.
Is anybody disputing your citizenship?
No,
Then where your father's name, whose name is required here?
no, here, because that was the land
Come
which
to
was,
the eviction,
yes, eviction.
impugn notice.
Impugn notice is in page 37. Now, the thing is
It's a
that
similar, same
Yes.
date, same order.
same date, same, only name is different.
Name is different.
Everything is same.
Including item 22, 21
21
also.
also same.
21 also,
Yes.
same day.
Location is different.
No, the location I've understood.
Yes.
The impugn order is same day?
Same.
That
Same,
I'll have to
same.
just check. I'll just check.
Yes, yes, check it.
Yeah.
Okay. Yes.
Then impugn order was issued in 13/3/2024. So now the question is whether the forest department has the authority to
And this is second eviction notice.
yes, civic eviction notice, and the first
Ah,
eviction notice
You
was
just read it.
I will read it. Eviction notice, whereas a SOCUS notice was served to Mukesh Deori White memo number this for violation of this regulation is adopted by the state of Arunachal Pradesh under rule ejectment of unauthorized persons from reserve forest rule 2013. Whereas the representation claiming the authority of your occupations by your representations dated letter number nil dated this is not accepted by the undersigned as per provisions given under rule this unauthorized. Whereas eviction notice was also served to Mukesh White this dated 6/1/2023 for violation of this as adopted by the this. Whereas Mukesh Deori has encroached upon Dayun Anchal Reserve Forest in Sumpoi village land covered under the government notifications dated 1982. And the forest land is used for cultivation purpose without acquiring forest land clearance from the concerned authorities. And herein after violation of government notifications dated the said encroachment made by Mukesh Deori is without the explicit approval from the government of India. Therefore, I see this in exercising power conferred under this Arunachal Pradesh order Mukesh to vacate the encroachment reserved land within 15 days from the date of issues of the notice, failing which he will be evicted from the reserve forest area and the cultivation area will be considered or demolished. No compensation for loss of such property will be given to unauthorized occupants. Now the question is whether the forest department has the authority to issue this particular eviction notice when the land was already diverted.
It was diverted.
Yes, Your Honor. Can I
So
come to
was
page number 16?
Except for showing that this is what is called a village, recognized village.
Yes,
You show
it's
us the
page number 16, annexure 1.
16.
Yes.
Page 16.
16.
10.
16.
16.
16. 16.
16. Yes.
May I read? Dated 7 December 2021, the government of Arunachal Pradesh has renewed and approved diversion of 7.11 hectares of forest land for oil dealings location at KUP in village Sumpoi 1 and Madukunala. So they had already diverted the land from the forest land. So after in 2021, they had already diverted. Can they issue SOCUS notice after this diversion?
Diversion is for, what is for? Diversion is for
For-
oil drilling location.
While dealing in village Sumpoi 2, that is specifically mentioned.
This is too technical.
Because it is, because had they had said that within the reserve forest, it was diverted, then my village could not have been covered. Now they had specifically mentioned in village Sumpoi 2. That means that village was existing. That is a
What
survey
is
village.
that? The approval diversion of 7.1 hectare of forest land for oil drilling.
In village of Sumpoi 2.
Simpoi 2 and Simpoi 2 and.
And Modokunala. This is same two area, two locations.
This is by whom?
This was by the additional deputy commissioner who had given information to the divisional forest officer.
Yes.
And then after that,
So number one, you are saying that the authority who has issued the eviction notice
eviction notice
is not a
Has-
competent
is not-
authority.
authority, because one, it is diverted.
It's already been diverted.
Already been diverted, because had it not been diverted, they could have issued a notice, because the date of Showcase notice is after the diversion, which was confirmed by the authority itself in 2001. They had issued the Showcase notice only in the year 2022, 23, and 24. And in 2022, there was a Minutsa meeting. A meeting was conducted at the EAC office. It's in Annexure 3, page number 19. Wherein it says a meeting was conducted on 17/1/2022 at 1100 hours in the office chamber of EAC Dayun for a preliminary discussion to work out a solutions for implementation of oil drilling work at location KUP and KUL. This village PML at village Sumpoi 2 and RF Modokunala. Now, the head came to the last. At the outset, the EAC Dayun briefed the members on the complexity of the granting compensations for the locations Sumpoi 2, KUP and Modokunala, KUL. Since both the locations fall under RAF, RAF cannot be guaranteed to individual occupants. However, since occupants in both locations have been enjoying their occupation since 20-30 years.
And next ground.
This is the, and based on this, they had issued, the EAC Dayun had issued a circular in 21 April 2022. In view of the meeting conducted with the stakeholders of assets in Sumpoi 2, oil drilling KUP, a survey will be conducted on 5/5/2022 at 1000 hours at the location to assess the assets of stakeholders for further submission to the deputy commission. Means even the authority themselves accept that there is a surveyed village. So the assessment is required to be made, a survey is required to be made of the property, and that has to be submitted to the authority concerned for payment of the compensations.
See, if you are unauthorizedly using the land, how can you, the land, the property itself is illegal? How you will be, whether the question of assessment?
No, the question,
Suppose we are cultivating the land, which was under the reserve forest illegally, without any permission, whatever. How can you claim a compensation over the standing on the land, which is not, I mean, your.
No, here the
which
case
you
is
did not
different.
possess
Here the
legally.
case is different. The village exists before notification was issued.
Huh?
Village was existing before the notification was issued. Because as per the cadastral survey report, 1979. And the notice was issued only in 1982.
So are you challenging that? Nobody challenged that.
No, notification for the first time only they had disclosed about these particular notifications.
Okay, your village as such, actual village has not been affected. It's the constructs and the cultivation which you have done and which you are.
No,
doing.
it is within the village.
Maybe within the village, but not where you are staying.
No, that is my residential area.
How
only.
can you cultivate those things?
Those are areca nuts plant, areca nuts and tea plantations within the compound of my residence only. Because it was surveyed in 1979.
Next ground.
And as per the minutes of meeting held with the ESC, he had proposed for that the common consensus was drawn that at
That
least
is common compensation, it has not been
at least for that
brought to logical conclusion. They want to settle.
and then this survey report is there.
Of what?
That village survey report about the allotment land and how many lands I occupies and all these things.
Where it is?
And that is in the,
Who is given?
it's in page 30, annexed
Huh?
Sitar for survey village.
No, that you have seen it. Who is the report? Who has given this report?
This is by the Mandal,
Hmm?
government of Arunachal Pradesh. It is available with the extra assistant commissioner Dayun, this particular registered
Okay,
land
okay.
record.
Then
And accordingly, I pray for the compensations. Since I'm in the occupation of the land before this notification was
if
issued,
it's a
and
forest land,
No,
until the
you-
time
no.
it is, the notification is challenged and satisfied
No,
or
what-
it is denotified.
for the first
It
time,
back to square again, what I've said,
no, for the first time only when notice was issued to me, I had submitted SOCUS, reply to the SOCUS notice stating all the details. That since when this village was existing, and I informed that I was not aware, even then about the notifications also. Only when notice was issued, then only they had informed that this comes under the surveyed village or Dayon Anchal Reserve Forest. Otherwise, we were enjoying since its establishment way back in 1962.
So
That is my submissions only because
facts remain that it is a notified forest area,
this
reserve
is,
forest.
as per
As
the
on today.
notifications,
As per notification, you are
As
not,
per
you are
notification.
not challenging this.
I'm that this because I applied for the RTI about all the notice and circulars they
But
had
facts
not
remain
produced.
that as on today you have. not
As on
challenged.
today, we had not challenged.
Matter ends there.
That we will be challenging that very soon because
That's
they have
up
not
to
supplied with the
we
copy.
cannot make you answer.
That's
That's all.
That's all, yeah.
Either compensation.
Yes, because we are not,
If
we
you-
are ready
if you-
to part
if you-
with the
if you-
land because
if
it's
you-
an.
If you had to vacate, you are seeking compensation. You are
Yes,
asking for compensation
only for the compensations
of what?
of the property which is existing, the areca nuts and tea plants, which even
Areca nut and tea plant.
tea plantation, it's 30 years, more than 30 years.
Ah,
Because
Then-
our livelihood is there only, because panchayati, because this is a panchayat area where the interest of the local people should be capped.
which one?
This is a Anchal Reserve Forest, so the interest
We'll not
has
go
to be
into all.
capped in.
Is there any provision for compensation?
50% shares should be given to the Anchal. Because land compensation go as a revenue, and whatever revenue comes, 50% has to be given to the village.
Do you have the panchayat system there?
Yes, panchayati, village
No, do you
panchayat.
have the panchayati system there?
Yes, we have the panchayat. We have GPC, even the present petitioner is the JPM, Jila Parishad member.
Okay. Hmm. Okay.
He's the Jila Parishad member of Dayun Jila Parishad. That's all.
That's all.
Yeah.
Same.
I will add to that, whatever he has argued.
Hmm.
So my,
Don't repeat what he has submitted.
yes,
Yours is Sampol,
Sampoi two.
Sumpoi, Sumpoil,
Yes,
Sumpoi or what?
yes, Sumpoi, that village.
SISUPOI, Sumpoi 2,
Mine is Madhuko Nala.
Madhukana.
But Madhuko Nala, that was
How many
earlier
petitioners?
names. Total 8 petitions are there.
Yes.
Otherwise,
One petition,
8.
one petition,
No, 8. Total.
one petition, 8 petitioners.
It's a common petition, a petition.
That's why I'm asking, how many petitioners in one petition?
Total 8.
Okay,
Eight.
item 21.
Yes,
And the same eviction notice.
same eviction notice.
Date also,
There's also same.
including the date,
Yes,
nah?
except the area is different. And in my case is that the Madoko Nala, that village has been renamed in 2006, and it has been known as a Madokonong. And it is a gazetted, it is a recognized village through the gazette notification. So I will just take to that notification. It is in page 39. In the eviction notice, it is mentioned Madoko Nala. But whereas this is it should have been page is 39.
39.
Yes. 39 may see the last paragraph. It's mentioned notification 31st August
The
2000.
interest of public government
Six.
relation, please to accord approval
So,
for
in the-
renaming of the following town villages is recommended respective deputy commission. Modaka.
Number 3. Tanglang district,
Nala is
Madoko Nala as a
Modokonong.
Madokonong. So this is a village and this was notified in 2006. And what about the drilling which the respondent they wanted to do? It is coming under this Madoko Nala, and it is Madokonong. So it is a recognized village area. I'll say that is one. Second is that I want to bring out is that there was a cross complaint. Earlier complaint, they also went to the NHRC. The NHRC also said that there should not be a forceful eviction, and then if their property is being affected, then they should pay compensation. And then the respondent number 3, they also undertaken saying that we are not doing forceful eviction. We will assess the property and we will take necessary actions. That is as per the directions. On the basis of the undertaken by the respondent number 3, the NHRC was pleased to pass the order saying that there should not be a forceful eviction. Their property should be taken care. So I may read that one, that order also.
Where it is?
Page 50, it starts from page 52.
Fifty
52. 52.
National Human Rights Commission.
Yes, you're also. So may I read that one? May I read that whole judgment? The complaint has drawn attention of
Oh, it's
the
okay, where it is. Relevant.
relevant. I may read.
In view of the reply of Minister of Petroleum and Natural Resources that no forceful eviction to be made without paying compensation to the affected with action be taken. This has been closed.
Yes, this has been closed. Mr. Seth. And direction was that as per eviction notice, it was issued 13 families. 13 families was issued, and who have been issued notification by the Forest Department and the EAC, the UN project affected families as per the Rasas and such.
Where you are reading?
That 53. May I read from the 52 last 3 lines?
No, I have read it. In view of the reply of Minister of Natural Resources, there no forceful eviction to be made without paying compensation to an affected.
Yes,
person.
yes. An action to be taken
Then
according with the law.
next,
So this was the direction.
these are including these.
Including
Your
yes,
writ
two
petition.
locations.
KUP and KUN.
KUP and KUN.
Huh?
And then total area is 7.11
Tokonala
hectares.
and Sampoi village,
Yes,
both.
both you all said.
Yes, then
And then even the authorities also already my colleague has read out that minutes of meeting. May I just I will just go to page 84, my writ petition 84. 84.
And you are relying on the
84 also, there was a survey, may I just read 84, annexure 13. In view of meeting concluded with the stakeholders of assets in Mudukka Nala, the same which I have read, Mudukka Nala, all drilling location. There is two locations. One is called KU. So my case is a KUL. A survey will be conducted on 6/05
Is there any
2022.
proceedings like in your case? Same proceedings?
Same process.
Is it?
Mine is for 60, his is the 7 for the two locations, 2 days.
I was at the location to assess the asset of the stakeholders for the further submission to the DC Changlang. All the stakeholder requested. So this has also been done, Your Lordship.
Okay.
And I want to just read one of the definition as per the Right to Fair Compensation Act, Section 3. May I just read Section 3, subclause 4 and 6. 4 and 6. May I read that one? As per this Lara Right to Fair Compensation Act, Section 3 defines family whose primary source of livelihood for 3 years prior to the acquisition of the land in dependent on forest or water bodies and includes gatherers of forest produce, hunter, fisher folk, and boatmen, and such livelihood is affected due to the acquisition of land. So they are to be covered under this. If the land is to be acquired, then they are supposed to be covered under this definition. And may I read the
Which
Uh,
one? Effective in memory.
4,
Whose land?
Section 3(4), subclause 4. No, no, no. Right to fair, right to fair. Right to fair. And may I read 6 also? A family residing on any land in the urban areas.
It's not
Oh, no,
urban
no, that's
area.
not 6, you're sorry. The important is only 4, Your Lordship.
So therefore, even if you are illegal occupants of the land, you will be entitled for compensation. That is what you are
No, in my case,
falls under the meaning of definition of affected family. So you
Yeah,
are
if-
entitled for
yeah,
compensation.
even if they don't have land also, if it is falling under
Hmm.
that affected area,
Okay.
then it will cover.
Next.
Well, in my case, the area comes under the village, notified village, and there is no any challenge.
So
and
in
that
his
not-
case, it doesn't fall, comes under
Yeah,
notified.
this is case is a bit different. His case is a survey something, but it is the village survey area. In my case, there is a clear notification, and that notification has not yet been cancelled. And as per this, their correspondence, and as per the deputy commissioners, this minutes of meetings and survey, my village comes under the village notified area. So
Okay.
when my village comes under notified area, then if the projects comes out anything, their rights has to be protected.
You have to go, but then whether you will be entitled for compensation, privacy will have to see. That's it. But you have to go. You have to vacate your cultivation.
Malut, first in response to item 21, Ananta,
Why you are relying this judgment of the Supreme Court?
Well, I'm relying one judgment.
National Human Rights Commission and State of Arunachal Pradesh. For what purpose?
No, that was the
You
complaint.
have
was-
annex.
I have annex.
Yes.
Yes.
Why you are relying?
Well, earlier, why I wanted to just show that earlier notification that was again that complaint was before the NHRC. Well, I have one judgment also here in this case also, but it was related to the land position certificate. So that's it.
Yes.
Malut, to reply item 21. Mr. Mouse case, my lord. This is
Yes,
the location is Modokko Nala. Modokka Nala.
your affidavit, you have filed the affidavit.
Yes, in our
Where is the
affidavit,
affidavit?
affidavit file,
Attempt 21,
yes.
affidavit. Yes,
In paragraph 3, we have categorically stated that the land in question does not fall under the village jurisdiction.
in read petition 403.
Yes,
It is
403. 403.
Ah, by
Respond
respondent number 3.
3,
Yes.
paragraph 3, my lord,
Ah.
page 114, my lord.
Hmm.
The answering respondent begs to state that the illegal encroachment area against which this office had issued eviction notices does not fall within the village jurisdiction of Modakkan Nala. In contrary, the land in question is far away from Modakkan Nala village. The fact is that this illegal encroachers, namely so and so, are inhabited of Modakkan Nala, and they have encroached upon fresh forest land under Dune Reserve Forest, which has been legally notified by so and so. Then in paragraph 5, the answering respondent reiterated that the land in issue is a freshly encroached forest land and does not come under the recognized forest village area. First of all, what their submission advance is that they are a notified village, recognized village, so they have to be compensated. The eviction notices which were issued are not to the persons who are in the village, notified village. These are to the persons, the petitioners, who have encroached upon the Dune Reserve Forest. It is not within the notified village. Yes.
Where is that rule? Under which the eviction notice has been issued?
Under the rule 2013, my lord.
Do you have that rule?
I have a copy of that.
That is has been annexed in the earlier writ petition, my lord.
Your case you have annexed.
Yes.
No,
Rules,
rules, 2013 rules.
No, yes, he had.
We have in the
India replied that.
in our reply we have
In
annexed.
your case.
In
Yes.
my case.
Okay.
So that I'll come to the
Whatever the properties, all these tea gardens,
property.
tea and the Arekanat compensation.
My lord, the illegal encroachers in the forest land, whether they can be compensated. When they are illegal, encroachers in the forest lands. Now they cannot even claim as a matter of rights under the Scheduled Tribe and Forest Dwellers, other Forest Dwellers Act, my lord, 2006 Act also. Since they are illegal encroachers on the forest land. Now, with regard to the authority, whether the divisional forest officer has the authority to issue eviction notices after diversion, that I will like.
Yes.
my lord. Then I'll, in item 9,
9 to 21.
9, the Sampoi village, which
Affidavit.
he is claiming, the
Hmm.
petitioners are claiming to belong to.
Hmm.
That itself is a village which is under the reserve forest.
Hmm. Yes.
Established under the reserve forest.
Hmm.
And they have no right, it is an illegal village.
Hmm.
As per their own showing, in the representation, my lord, at page 25. Annexure 7, my lord. We the undersigned are the villagers of Sampai 2 under Dune Circle oil affected people Sampai 2. A meeting was held under the chairmanship of HGB Mir Hiteswar Diori Sampai 2. After long discussion with the affected peoples, one resolution is passed that no compensation, no solution. Here one question arises with every people, how it come under ARF area, because Sampoi 2 is government recognized village. Sampoi is settled in 1964. The flood and erosion damaged the area with the Diori families settled. The Diori families represent the matter to the Deputy Commissioner, Tirap District, referred the matter to Divisional Forest Officer Miao Division to consider the land in Khagam settlement area for the Diori families. It was confirmed that Diori shifted to Khagam settlement area in 1964. Chandranath Diori was appointed. So the declaration of ARF in 1983 without any concern with the village people, even they do not have any knowledge about this. So why the forest department declared ARF whereby were already settled the village? We, the poor villages, landless people of Sampai request your kind pleasure to compensate us as per government, otherwise no. Meaning thereby they had earlier shifted, in the meantime it was declared a Anchal Reserve Forest. Again they have now shifted back. They have already, after declaration, now this,
No, you are saying that this Sarbet village,
this is already under the Anchal Reserve Forest.
how this is recognized village then?
Not identified.
Huh?
Not identified as a village. In
No,
our
no,
affidavit-
recognized village.
Not recognized. It is saying, they are saying themselves recognized village. We are, in our affidavit, we have not said, it's not a, it's a illegal village.
As a Sarbet village lacks substantiation and pertinence, thereby lacking merit. But they are produce annex documents. It's your own documents,
No, no,
not forest department, but the government documents.
but
It shows that it's a Sarbet village.
no, we are, they are unauthorized.
Hmm.
In our affidavit, we have clearly stated.
Hmm. This was, this notification was 1982.
1982.
And in most case, it is 62.
2006.
Huh?
2006.
No, no, notification.
Notification 2006.
Forest Department.
82.
Sorry, declaring
Sir.
reserve forest.
82.
Huh?
82.
82.
Yes, 1982. Same reason.
I think in your earlier affidavit is not 62. Is it
No, no,
typo-
they are claiming.
Huh?
Same reserve forest, 1982. Dune Reserve Forest, Dune Anchal Reserve Forest,
Same.
same.
Under the same DFO area, Lordship.
Hmm.
Same during reserve forest.
By same notification.
Same
notification,
notification.
1980.
Hmm.
Yes.
Because it's the same forest they are talking about, during reserve forest.
Hmm. Secretary Forest Government Department.
In their representation, sometimes they say that we were there, we were recognized as a village in 1962. In their affidavit, in the repetition, they say 1970. But the fact remains that it was declared as a reserve forest in 1982. And that reservation declaration notification as a reserve forest is not under challenge.
Okay.
Now, in our additional affidavit, my lord, in item 9, WPC 133,
Hmm.
we have said additional page 133, additional affidavit, page 24.
Hmm.
This was 13 October 2020, my lord. Here, in principle, approval was given, my lord, for diversion of
Yes.
7.11 hectares of forest land for renewal of forest clearance for oil drilling, location KUP and KUL under Negrud Petroleum Mining, so and so, so and so. This was in principle, approval was granted.
Hmm.
Thereafter, the approval diversion was granted in page 26, 25 February 2021 by this.
Hmm.
Diversion of 7.11 hectares of
This
land.
7.111, it includes both the areas, Madhukanara and
yes.
this thing. Yes.
For renewable forest clearance also. Ministry of Environment and Forest,
It's okay.
Government of India, so and so,
There's already.
has
Yes.
conveyed. Now, first condition is that the status of the forest land shall remain unchanged. Means the status, even if it is diverted, the status of the forest land will remain as a forest land.
Hmm. Legal status will be forest land shall remain unchanged.
Yes.
Okay.
The meaning thereby the forest authorities will have the right.
Hmm.
And therefore, the DFO, as per the rules of the DFO, still has the right to issue the eviction notice.
Okay.
It is not, although it is diverted, it is not the district administration who will exercise powers on the forest land.
Hmm.
So, my lord, in view of this, my lord, the other
So even
conditions
they are
and
not entitled for their properties or the trees,
illegal
even compensation.
encroachment over the forest land. That is, then rules also have been annexed in page 29,
Right.
2013 rules. That's all. Obliged.
My role in this litigation is very limited. Because it's ultimately an issue of an eviction notice vis-a-vis their status to that.
Huh.
My role is that I have my appropriate documents as well as clearance from the ministry as well as from the state government
To operate.
to operate,
Oil drilling.
to do oil drilling explorations for the nation's good.
It's okay.
Not for anyone's personal interest. But because of this litigation, we are not been able to proceed.
Okay.
And therefore, there has been loss for everyone.
See, you have the ministry, of course, the environment, they have said that they will assess the property at the certain compensation.
That is by the National Human Rights
Yes.
Commission. Now, National Human Rights Commission, we were not a party therein, number one.
Hmm.
And number two, as my learned friend was saying.
Here
if-
also the Union of India is not a party.
Who else?
Union of India is not a party.
Here in this litigation. They are a party.
Because that was on the assurance of the Union of India.
Yes, yes.
They are not party here, so we cannot take
So
into
respondent number
consideration
four,
of that.
respondent number 4, the Ministry of Petroleum and Natural Gas
Huh.
to Secretary Sastry Bhavan, New Delhi. Respondent number
Yes.
4 is a party here.
Yes,
Yes.
he had made a statement before the Human Rights Commission. On
No.
that basis, it was, their complaint was closed with a direction to consider,
Yes. Now, direction
taking
to
into,
consider.
taking into consideration of the statement by the Ministry of Petroleum.
So the
Yes, where
direction,
is Mr.
the direction to consider will also have to be in accordance with law. When you are
Yes.
considering, it has to be in accordance with law.
Yes.
If they are encroaching forest land, someone
where
encroaching
is,
forest land
where is
cannot.
the Deputy Solicitor General of
Mr.
India?
Madhu Kato.
Have you not served a copy to him?
No, he appeared in the last
Yeah,
occasion.
we have
He
served.
appeared in the last occasion.
Yeah. Okay,
He was available.
dispose of. We'll
My
record-
case would be, they cannot take advantage of an illegality. They have illegally encroached, raised some trees there. Now, if they claim compensation, that means we are regularizing an illegality that way.
Anyway,
And ultimately, the compensation will come to us. So therefore, our concern will be there.
My lord, I have just, I will reply only just maybe
Yes.
two points. So one he has said is that is as per his affidavit, may I just read his affidavit of respondent of 5. He has admitted that the drilling which is happening is in the village. Is a para 5. May I just read the para 5? Sorry, para 6 of page 91.
which village? Your village or what?
Respondent number 5 has filed.
Which village?
My village.
Simpoy or Madhukanol?
Madhukunang. Page 91. May I read just that paragraph 6? The deponent back to state that the IOC has proposed to drill at location. So my location is a pool.
Respond number 5.
Yes, respondent.
Affidavit. Para?
Para 6.
Hmm. Hmm.
Para 6, may I read it?
Oil has proposed.
The
to-
deponent back to state that oil has proposed to drill a location pool, which falls in the notified Dayun Anchal area under Maduku Nala area and Modoknong village. And in order to carry out any drilling activities, forest land, forest clearance, such and such, has also been obtained. Accordingly, OS has obtained forest clearance for locations such as, but then they have also admitted that it's in the village area.
What I have admitted is in the During Reserve Forest, as per my forest.
And then my reply to additional AG will be that what his argument was that it is a fresh encroachment. It's not a fresh encroachment. If you lordship see the
It's a regular
page
encroachment.
66.
Is it
page-
a regular and all the encroachment?
May I just read page 66?
And
Your
a
Lordship?
continued encroachment?
Page 66. May I just read that page 66?
Yes, read it.
Page 66 is the minutes of meeting. The meeting was conducted on 17/1/2022 at 11 hours in the office of Chamber of ESC Dayun for preliminary discussions to work out solution for implementing oil drilling works at the location Coop and Cool at village Sompoy 2 and Modokonala. So just next paragraph. At the outset, the ESC Dayun prefer the members of the company of granting compensation for the location Sampai 2 and Modokonala. Since both the location falls under the RF, compensation cannot be granted to the individual occupants. However, since the occupants in both locations have been enjoying their occupations since 20 to 30 years back, there shall be an unanimous consensus between the parties so that the walkout for the oil drilling could be started. Second, this is the officer representing the Ministry of Petroleum. That location at some
We've read it, we've seen it already.
Yes.
Ah.
Yeah, I want to just point out that this is not a fresh acquisition. It's all, this is 20, 30 years. They have been in occupancy. Your Lordship.
So continuous, the encroachers.
My lord, this is not continuous encroachment. My lord. It's a village and they have a garden, they have a tea garden, they have a battle lots, everything is there. Your Lordship. But then what they are trying to project is that the drilling which is coming up is not in the village,
It's a-
occupant area.
Occupied area.
But then it's in the occupant area. It's a occupant. And my case is, no, I have, your Lordship, I try to convey your Lordship is that comes under notified area, which also they also admitted that. Obliged.
Yes.
So that should be for
Then-
not, yes.
You have made a statement
Madam.
before the National Human Rights Commission
Yes.
that the, so far as the compensation and all the properties,
They are getting,
you,
they are getting.
they are getting
Yes. Then all the education, other things, madam, as per the directive.
compensation, compensation in this case.
Compensation, madam, compensation will be not required, and because.
You just show him, you do have the petition,
I'm sorry, madam.
that Human Rights Commission statement,
Yes.
order of the Human Rights Commission.
Page 53.
Specific direction means they may be evicted following the due procedure of law. That is the specific direction. The National Human Rights Commission never said they should not be evicted, madam. But in other cases, we use the direction of the National Human Rights Commission. So therefore, madam,
Last page, you read the last, the operating portion.
Here. In view of the reply, this part.
So in view of the reply of the Ministry of Petroleum, so the Ministry of Petroleum, no forceful evictions be made without paying compensations to the affected person. The actions taken taken in accordance with law. The complainant, if dissatisfied, the action taken is, I'm sorry, my lord, I have to check, this may not be.
We are disposing. We have heard all of them.
My lord. So this may not be the part of the judgment.
Hmm?
This may not be the part of.
No, it's a part
the
of your.
internal communications made between the judgment.
No, the human rights, that's the order of the Human Rights Commission.
May I just clarify? It says action be taken in accordance with law.
Hmm.
So when we are discussing on the aspect of compensation, whether by law they are entitled or not is a pertinent question that has to be decided. Yes, definitely. Is it if they are somewhere where they actually have a rightful right to remain and we are evicting them, compensation is a natural consequence.
Sir, I have understood. What I want to know from
Yes,
the
but this is
central
not-
government is they have made a statement and in a reply they have clearly said that without compensation they will not be evicted.
Another aspect, this may not be, I'm just, as per my understanding, I'm different. That's because, the National Human Rights Commission is one aspect, right? But another broader aspect is, they are the regular encroacher. They were allowed to settle in.
Now, why you have made a statement before there? These are the same people who have approached the National Human Rights Commission. And your ministry, in his reply, what they have said, you read just above that.
Hence, there is no question the arises of any forceful evictions without without paying compensations by the oil. This is one aspect. This is the. And ask for the comments of the complainant, if any, on the report that it's so and so within 4 weeks. In response, the complainant was furnished. The complainant has furnished his detailed documents, detailed comments by letter number so and so, dated so and so. The complainant has elicited the report dated so and so, submitted by Undersecretary, Ministry of Petroleum and the National Gas government is outdated and not based on the current facts at the ground. The 13 families of Motokonala at the rate of so and so village who have been issued notifications by the Forest Department and the EAC Diamond are project affected families. And as per section 3 of the so and so Act 2013 Act. And state government, in connivance with the Oil India Limited Company, are attempting to evict the project affected Chakma families without paying any compensation and rehabilitation as requires under the. One thing.
No, that is their claim.
One thing.
I just wanted to explain your reply.
This may not be always true, because another aspect is,
No, it's not a question of true or false. It's a question of you have made
Another
a
aspect,
statement
brother,
before the commission that you will be They will not be evicted without
Ministry of, and Petroleum.
Ministry of Petroleum, who is a party here.
Yes. Malad,
That's one number 4.
another aspect, broader aspect is, Malad,
Hmm.
the compensations, who is entitled for the land compensation, Malad? Please, that is the only one thing.
You know, these people had approached the Human Rights Commission.
Huh.
You were also given an opportunity.
Yes.
You made a statement. In your reply, what you have said is they will be a given compensation. Of course, they will not be affected without given as per the law.
Huh.
All right.
Land compensation.
How do we decide? I mean, why not binding on? They should not bind on us, but then see the statement and the making a, statement before the commission.
Another broader aspect is, Malad.
We just
They
cannot
don't
brush
compensate-
aside also.
Malad,
That's why I want to hear you, why you have made this statement.
Another broader aspect is, Madam, the land compensation will be allowed only to the citizen of India, Madam. So therefore, Madam, the status of these peoples are still.
Not these people, only item 21. If you agree to your, if it is accepted.
I'm-
So far as this, their citizen.
Citizen, Madam, it is also doubtful.
Who?
The Chakmas, none of.
No, I'm not talking about, let us not take by name, let us go by the number of their reputation. There are 2 reputation. Item 9 to 20, there is. There is,
Yes.
right?
There will be entitlement.
Ah.
And
See,
rest of the.
No. As a citizen, they will be entitled, but whether legally they have the status to claim compensation is arising out of a
that's
statute.
why I want to know from him.
Compensation will come from a statute. It cannot be in open air.
You
in
have to
thin air.
pay, what's that is, of course,
Under the compensation
you are the
statute,
authority
they are
who
entitled.
has to pay. Beneficiary.
Yes.
Now your ministry
This is
says
a-
that they will be paid compensation.
in accordance with law, So it has to be first checked whether under the act, they are actually entitled or not. Under the statutes for
We'll see.
compensation, they are
We'll
entitled or not. That exercise cannot be taken away.
We'll
Or that
see.
right cannot be taken away. Because ultimately public money
Okay,
is what is depending here.
that's all. Hmm.
If they are
Heard
entitled,
Mr.
yes.
DK Deori, learned counsel for the petitioners in item 9 to this thing, na? 20. And Mr. Esmo, learned counsel for the petition in item 22. Oh, sorry, 21. And also heard Mr. N. Ratan London, additional advocate general for the state respondent number 1, 2, and 3. 1, 2, and 3.
No,
And
my lord,
1, 2, and 3.
in
So
item
parties
9,
are different.
I
It's all
will be
right, 1,
for,
2, and 3. And Mr. M. Kato, learned DAGY for respondent number
4 and 5, Madam.
4 and 5. And Mr.
5B.
I'm for
Only 5. four, five.
from item number 9 to 20, I'm respondent number 8, and in 21 I am 5. So Lordship will say A Sharma for Oil India Limited.
All India Limited.
Oil India Limited.
For state respondent and union,
And-
the union, of
Yes,
India. That will be
That
better.
will be better.
Right?
Lordship. Yes.
Additional advocate general for
state respondent.
state respondents, comma, Mr. Suen M. Kato, DSA for Union of India,
Yes.
and Mr. A. Sharma for All India.
Oil India Limited.
All India Limited. Respondent All India Limited,
Now it covers
respondent
them.
Union of India, respondent states, huh? See, just that. Pass down.
Obliged, Lordship.
Obliged.
Obliged.
We'll pass down that.
Yes, yes.
We'll see today, if it's not possible, we'll make it see.
Your Lordship. Lordship, this matter may be kindly adjourned for today for filing of
What,
rejoinder.
what item?
Item number 25. Rejoinder.
Secretary, what is this? Filing of what?
Rejoinder.
On the prayer of MS So-and-so, and counsel for the petition, for the 3 weeks time is granted to file, for filing affidavit in reply. MS Arbus at London, the state council is present, huh?
In the item number 5, Lordship.
Yes.
My lord, I'm sorry, I'm not there in the item number 5. Because of the confusion, my lord.
Cannot be.
Right.
That too by,
No,
that too,
Lordship rightly pointed out.
you are the second senior most of the lawyer in the state.
It happens, my lord, sometimes.
No, that's what I'm saying. Cannot, it would not be. It cannot be. So what is to be done?
Lordship, can it be after 2 weeks, Lordship?
Okay. Otherwise, I thought disposing of the matter. Why you are saying 2 weeks? I said that the writ petition is dismissed.
Lordship, so why, Lordship? Because I have a good case, Lordship.
Anyway.
Lordship,
Heard
since-
so-and-so, huh?
Yeah,
Writ petition. And judge any then consider the petition in writ petition, huh? And Mr. R. Sankhya, run counsel for CRP, huh? Land council petition and CRP so-and-so.
Lordship, I am for state respondent.
And Ms. GAT for then additional senior government for state respondents and Mr. Decent land council for respondent number 1, 2, 3 in CRP, huh? Not in writ petition. Next para is agreed to by land council for the parties. Let these matters be listed after 2 weeks.
Lordship, there is a stay, Lordship.
5 and 6, huh? 5 and 6. That's 5 and 6. I think 5 and 6. No.
Lordship, there is a stay, Lordship.
Interim order passed earlier shall continue.
Obvious. On the last question, there's a direction to produce
Yes.
this notification.
That water
Yes, ma'am.
regulatory authority.
Ma'am.
Lordship, this is there, but that Lordship, after this, Lordship may kindly come to,
Just wait. What is the
Lordship, this is from the joint secretary. And then Lordship, so far the factual matters are concerned, Lordship, I would
so
like
there is
to.
no authority under the act. No authority has been appointed or
Seemingly, Lordship,
established.
Lordship.
So it is doesn't
They don't have a regulatory body, Lordship. Seemingly, admitted.
so repetition is maintainable.
No, ma'am.
Okay. Okay. Why this issue has cropped up?
My lord,
You are saying that although there is an act,
my lord.
it has not been implemented or brought into force.
No, my lord. Fact that remains a dispute regarding the entitlement of water. But our difficulty is, my lord, aggravated because of the absence of any such authority, my lord, before which we can go, my lord.
That's why
My
it is admittedly there is no authority
My
under the act.
my lord.
It's only only on the paper.
Paper, my
It has not been enforced. It has
My-
not been
My lord, here,
So-
of course,
So now you will be deprived of the water for
my
cultivation. That's the issue.
lord, amongst other
And-
usage.
And you are not saying that you are otherwise you are also I mean otherwise you are also not oppose the
No,
uh,
my lord, I
project
cannot,
also.
I cannot that, I cannot oppose. Sir. Well, here, of course, otherwise now there are two versions, my lord. Here the petitioners versus it's basically the department, my lord.
Ah.
The department says basically there is enough water. They say this is the amount of water that is available. But they have never said that this much of a requirement is for the agriculture purposes. Suppose they are saying that 50 MLD is available, but they do not know, they cannot say that what amount of water would be required for those.
That in
Yes.
that case
And-
the public this health water supply department may not have that idea.
My lord, of
I think
course,
it
my
would be by the water resource.
lord.
Water resource.
My lord, but otherwise also this requires some factual, basically this is a factual dispute as well, my lord.
Yes.
So basically, my lord, this
Which-
court
which-
also doesn't have the expertise to decide on it.
Yes.
So, my lord, today, my lord, in fact, I would pray, my lord, that since it is very clear, my lord, otherwise the act envisages there's a mandatory duty that they should come up with some body, my lord. It is not there. So what I'm praying, my lord, this can be disposed of, my lord, with the direction, my lord, to the chief secretary, my lord. Let them constitute some committee for this specific, let them decide, my lord. Because this aspect cannot be decided by this court, my lord. What I'm praying today, my lord, let the chief secretary that constitute a committee constituting of the PHE, water resources and agriculture as well, my lord. And let them decide, my lord. What would be the best way out, my lord? Because otherwise the verification report also, PHE says, you take some immediate measures for irrigation purpose, my lord. That is in the project itself, my or verification report itself, my.
This project has the project been completed?
Not yet,
Lordship, is 80%, Lordship.
not completed as of yet.
80%. Otherwise, actually, what I was saying is, Lordship, at my para 10, Lordship, at my para 10, page 49. Lordship.
By whom? Respondent number 6.
Yes,
Yes, ma'am.
by the
That's why-
PHE department. What
Executing
they
it.
say is,
Respondent
executive
number
agency.
6.
Here we say that, Lordship, the answering respondents begs to state that survey of various sources in West Siang district were carried out to select suitable source of water supply to Alo Township.
Just wait. This is affidavit by respondent number?
Lordship, there is only one affidavit, Lordship.
6, my lord, 6.
Six, yes,
That's the
Affidavit
executing
in
agency,
opposition,
ma'am.
Respondent number 6. Yes.
page 10, para 10, Lordship,
Oh, para 10.
yes,
Yes.
page 49, Lordship, para 10. Here, I am continuing, Lordship, here. Lordship. Hilly source located at Bay village was selected. Hilly source is giving 48 MLD discharge, out of which 7.7 MLD is to be tapped for drinking water, Lordship, and the rest 40.3. Out of 48, Lordship, only 7.7 is being taken. So what remains is 40.3 MLD to again go into the Hu River, Lordship. As per customary law, people of Bay village are the owners of this.
Can I decide this matter?
So,
Yes.
Lordship, from 48.
Can I
only
decide? I
7.7.
would be I am also the consumer of this.
Yes, it
So
doesn't-
can I decide the matter?
No.
Can
it
I take
doesn't-
up the matter?
Lordship, from
Not presently not. I'm not a consumer. I would be the consumer.
no. What
This
we
board would be the consumer. One point of time.
Lordship,
Can I decide this?
everyone is consumer, Lordship.
No, especially it's for Alo. Na?
Yes, of course, Lordship.
Right now,
Lordship, what we have said
Well,
is,
that's all,
Lordship,
my lord.
it won't affect the downstream.
no, what
much.
he has also understood, he has fairly submitted. What he has
No,
said
of
is,
course, Lordship.
when if you
I don't
say
think-
so, since the PHE and water supply may not have that expertise, all the technical is, will not go into it.
Ma'am.
And since the claims are disputed, can there be a committee to look into the matter.
My lord, that-
If it is correct, the figure, I mean, the figures which you have given, this 40 is always remain there, only 7.7 LD is taken out for augmentation of this water project. Then they'll look into and see if it is correct.
Lordship, this, I think, from the expertise only they have made out this, Lordship.
Yes.
Unless there is
It's-
expertise, they won't give this, Lordship, bigger.
No, my lord, what my
Yes,
suggestion
no,
is,
well.
Yes. Next week, we'll dispose it off. Let me
Yes, sir.
apply my mind also. And let me take a call
Even my Lordship.
whether it would be
it has,
appropriate to take up the matter also.
explained clearly my para 7 also, Lordship.
No, we'll hear you on next week.
Yes,
His prayer is very,
Yes,
very
Lordship.
simple now.
I agree to that.
We had,
I
we
have
had
no,
tried to enter into a complicated area
yes.
of all this act implementation and all those things. Now when
Lordship, my
he
only
has
worry-
simply, now because of your instruction and
Yes.
he has simplified his the case.
Yes.
I think he's done a good job.
My only worry is that directing a.
Is there any interim
committee
order?
Now,
no, my lord, there's
If
nothing.
there's no
We are
interim
not
order,
even praying for, my lord.
you think about it.
Yes,
yes, Lordship.
Number one, whether I can take it up, this court can take it up, the matter. Number two, his submission. Simple prayer for
I'm only-
constitutional committee to look into the matter.
Lordship.
We're not passing any, I mean, adverse
No.
or kind of thing. Heard Mr. Dish of Learned Counsel for the petitioners. Petitioners.
petitioners.
And also Miss G at the London Additional Senior Government Advocate for the state response. By placing the communication next para, that is 16, copy of the communication that is 16/06/2325. MSG at the London State Council has submitted that there is no authority constituted under the Arunachal Pradesh Water Resources Regulatory Authority Act. Which year? Act of
Act of
2006.
my lord 6.
2006. However, the Water Resources Department is the designated state nodal department. Mr. Having considered above and considering the nature of the grievance raised in this petition, let this matter be listed and on after a week for final disposal. We'll dispose it next week.
Can it be fixed because I might go out of station on 26th, my lord.
Make it
Can it be 25, my lord?
25.
All right.
Obliged.
My lord, Lordship, I beg to mention item number 41 for adjournment. Lordship, leading counsel is out of station due to suddenly demise of his family member in this morning.
Who?
So, leading counsel is Mr. T. Topu. This morning, suddenly one of his family member is demise because of
Yes, Mr. Regum.
My lord, I am for the petition.
So no objection.
If leading counsel is not- one-
Mr.
I'm Mr. Tabat T. Takyang.
Learned
Oh.
Counsel submits that on account of the sudden demise of the relative of Mr. T. Topu,
Yes, Your Honor.
Learned Counsel appearing for the respondents,
6 and 7, Lordship.
respondents 6 and 7. Mr. Topu had to attend the had to leave, to attend the funeral of his relative. Therefore, prays for listing of the matter. After 2 weeks,
Okay,
2 weeks,
Lordship.
3 weeks,
Lordship, after vacation,
2 weeks. Instead of having prayer not being objected to by Mr. N. Kago, learned counsel by the petitioner, as well as Mr. N. Long, learned senior government advocate. And considering that the leading counsel, Mr. Topu, is in bereavement, let this matter be listed. After 2 weeks, huh?
Okay, Lordship.
Praise aloud and let this matter be listed out. Continuation, huh? Having considered so and so. Praise aloud, wisdom, then let this matter be listed.
Much obliged.
Yes.
Well, it's a tender matter. There's no interim also. Readings are complete. Can it be taken up for disposal?
Ready?
I'll not, I'll take 10 minutes. I'll just show my documents and the documents of the private.
But I may take 2 days. Yes.
So Lordship, may kindly have page 23.
Yes.
At the very outset, my lord, the annexures are, I'm extremely sorry. They have been not annexed in a proper sequence. I may have to take your lordship here and there. Annexure 2 at page 23. This is 6th of March 2025. This NIT was issued for construction of 20-bedded hostel building, including kitchen and dining hall with warden room and such and such, such and such. So on the same day, my lord, 2 other NITs were issued. I bid submitted by in respect of all 3, man, that I have reflected in my affidavit in reply. All 3 on the same day. That is on the last day of the submission of bids. So before I take your lordship to as to why my bid was rejected.
This is what is the date of the tender?
6th of March 2025.
Okay. 20?
25.
Okay.
Your lordship, may kindly have
construction of
20-bedded hostel building, including kitchen and dining hall with warden room and 4-unit double-story type 2 quarter room. Telam. Your lordship, may kindly have the standard bidding document at page 31. Page 31, it starts. Relevant would be 44. Page 44. Clause 4, my lord. Page 44. This is the eligibility qualification of bidder, clause 4. Your lordship will kindly come to the next page, 4.3. 4.4a. To qualify for the award of the contract, each bidder should have in the last 5 years achieved in any 1 year a minimum financial turnover as certified chartered accountant and a lower 50% of which the civil engineering. 4.4a, my lord.
4A. Yes.
A, I am reading, achieved in any 1 year a minimum financial turnover as certified by chartered accountant and a lower 50% of which is from civil engineering construction works equivalent to amount given below. B, my lord, this is important. Satisfactorily completed as prime contractor or subcontractor a lower one similar work equal in value to 1/3 of the estimated cost of work for which the bid is invited or such higher amount as may be specified in the appendix to ITB. So this is the eligibility criteria. 4.4AB. Similar nature of work. Then 4.4B, will border lordship only with subclause 2. This is also a requirement. And affidavit, this is the ground on which I have been rejected, that is why. An affidavit that the information furnished with the bid documents is true and correct in all respect, and such other certificates as defined in appendix to ITB, failure to produce the certificate shall make the bid non-responsive.
Yes.
Yes. Then your lordship will kindly have the next page. 4.7. This is one of the grounds on which my bid was rejected. Even though the bidder met the above qualifying criteria, they are subject to be disqualified if they have made misleading or false representations in the forms, statements, affidavits, attachments submitted in proof of the qualification requirements and or record of such and such. I am basically on the false representation. 4.71. Then your lordship will kindly have section 3 at page 62.
Qualification information.
Yes, qualification information. Then at the next page, section 3. The information to be filled up by bidders in the following pages will be used for the purpose of post-qualification, my lord. Post-qualification, as provided for in clause 4 of the instruction to bidders. This information will not be incorporated in the contract. Attach additional pages as necessary. Then your will kindly come down below 1.3.2. B, my lord, the last portion. I have to provide information as regard to works for which bids have already been submitted. So this was the requirement. So if your lordship now kindly have the affidavit, my lord. Oh, no, sorry, man, sorry. I'm sorry. So this is the requirement. I have to show bids for which already have been submitted. 1.3.2 B.
B.
Your lordship kindly comes back to page 27. Manuals of technical bid evaluation. I'm a Nane Enterprise. Non-responsive because of 1.32 B of section 3. There were 3 bids, my lord. 3 NITs were issued on the same day. And the last day of submission of bid was also on the same day. I submitted my bids in respect to all the 3 works on the same day. So I said nil in the 1.32 B. Because I submitted on the same, there was nothing pending. I said nil. So it is on that ground, my bid was rejected. And 4.7 is that is because misleading statement, because I said nil. 4.4B also wrong affidavit. This was the initial from the section that I have understood. Admittedly, I have said nil in all the 3 bids. So it is on this ground, my lord, my bid was rejected. My submission is, my lord, when on the last day I'm submitting bids at around the same time, there was no bid pending. So I correctly said there was no bid pending at that moment.
The submission of bid pending is to have the experience or something else.
Maybe, man. That is why by section 3 is a post-qualification. So that could not have been a ground for rejecting my technical bid. Now in the affidavit they say.
That's all.
Yes, that is the ground matter.
Okay.
Now I am coming to the private respondent also. Now in the affidavit, my lord, they have said something else. That is why I'm. If lordship have the affidavit of the respondent numbers 1 to 5. Huh? Yeah. 1 to 5.
Which one? Which affidavit?
1 to 5. Affidavit of opposition. There are various documents are missed out. So many additional affidavits are there. So that is why I have incorporated all the documents in the reply, madam. Government affidavit.
Respond number 1, 2, 3.
1 to 5.
Next should have been Next should have been there. Affidavit industry. 125. 125.
1 to 5 years.
Yes.
At page 728, paragraph 6.
Yes.
Then with regard to statement in paragraph 4, such and such and such. Number 1, 4.4BA2 of section 2.
Just wait. Yes.
The bidders were required to submit geotext photographs of site visit along with such and such. However, the petitioner neither obtained the counter signature of EE nor submitted the geotext photographs taken from EE. The petitioner in his site inspection statement he had visited the site of the proposed such and such, such and such. What I'm submitting is 4.4BA is not this. They cannot improve it in the affidavit in opposition. 4.4B is matter. An affidavit that the information furnished with the bid document is true and correct in all respects. That is the requirement under 4.4B2.
4.4
B2.
BA2.
Yes, BA2.
Hmm.
It says an affidavit that the information furnished with the bid document is true and correct in all respects, and such a survey is defined. This is something I have to furnish. The affidavit was there. They have changed it, my lord, in the affidavit. My lord knows that's a public order, my lord, by the competent authority. They cannot improve their case in the, my lord, by filing an affidavit in opposition. And my site visit report is there also. Then your lordship will have the second ground. Clause 4.71 of section 2. That the annual turnover documents of the petitioner did not tally with the records, did not submit, nor were any supporting documents regarding the extent and volume of works executed in each year. Therefore, the information was evidently false and misleading. This is also incorrect, my lord. I can show in the affidavit I have annexed my bid documents. I will show that, my lord. Next one, my lord, I'm admitting, I said nil. Because 3 NITs were issued on the same day. The last date of submission was the same day. So when I submitted the bids, there was no bids pending. So I said nil in all the 3 bids. I'm admitting it. But that could not have been a ground because there was no bids pending, my lord. So that is the 3 grounds. Now your lordship may have the turnover certificate in my writ petition, which they say no documents. I don't know what they mean by that. That is at page 139 of the writ petition.
I said that's there tell you with the records.
I don't know what they mean by that.
Yes.
Turnover certificate is page 139.
159.
39, man.
39.
We have done a fair amount of minor tender matters. This is the way it is furnished. And this is the format they give. Last 5 years, my lord. Total turnover is there, civil work turnover is there, net profit, everything I have given. (4.4A)(B)(2), my lord, is incorrect. That is in respect of something else. Only an affidavit I have to furnish. That is there. So turnover service also there. Nil, I'm admitting, my lord. My lord will take a call on that. In my humble understanding, when I submit a bid on the same day, there was no bid pending. That's why I said nil. And all bids are open on the same day, my lord. Bids were also open on the same day. I will show it, my lord. If your lordship kindly have my affidavit in reply, my lord, to the affidavit filed by the respondent number 1 to 5.
Which page?
Page 757.
Seven hundred and fifty-seven.
Has my lord got it?
Hmm.
This is the first NIC the NIT we are concerned with. All are dated 6th of March. Last date of submission is all 19/3/2025. This is the
Same-
first.
same day.
Same day. First NIT, NHRA. Second NIT, your lordship will find it at page 761
Hmm.
by the same authorities. Last date 19/3. 761, my lord. This for another work. Same authority, executive engineer, Ardiludi Likabali.
Same.
No, the place is different, man. This is Nari. The first one is Telam.
Telam is your concern.
You were concerned with Telam. This is I am showing, my lord, on the same date these
Okay.
three were issued. I bid for all of them. And that is the reason, my lord.
Nari, and then
765 is for Seren. This is a different word.
Hmm.
So these are the 3 dates on all submission dates was also same. Now, my lord will kindly see, this is a part of pleading in the repetition, but we could not annex documents properly. If additional affidavits are there. So I have brought it on record by the reply. Your lordship will kindly have 769.
Hmm.
My lord, recall similar nature of work certificate has to be submitted in terms of the contract, my lord. Conditions of contract.
Hmm.
This is, my lord, completion certificate submitted by the private respondent, the beneficiary.
Hmm.
This is dated 20 May 2020.
Hmm.
Name of the work is care of 100 bedded girls hostel at GSS Dayun. This is in Changlang district.
Hmm.
2020. My lord, kindly note the date. 20th of May 2020.
Hmm.
Then, my lord, will kindly have page 770.
Hmm.
This is 18 February 2021. The private respondent was enlisted on 18 February 2021 under class 3, under civil category. The work completion is of 2020.
This is in respect of the respond number 6.
6.
Okay.
And the value of the work is 2 crores. 203 lakhs. Why, my lord? To substantiate that it has to be a forced document, my lord will kindly have page 772. This person is from Lower Siang district.
Hmm.
Categorically says the work is at Changlang district completion certificate.
Hmm.
The lordship may kindly have 772. This is the district-based entrepreneurs and professionals act, my lord.
Hmm.
Your lordship 773.
Hmm.
Above 1 crore to 3 crores, all registered contractors in class 3 and 2 categories domiciled within the territorial jurisdiction of assembly constituency. He could not have been awarded a work there.
Changlang.
Yes.
Apart from the
Yes.
year of
Yes. Domiciled within the territory of the assembly constituency.
domicile and a year of completion.
Yes.
Because he became a contractor in
Yes,
2021.
yes. There is also there.
Okay.
And there is an RTI reply at page 775.
Hmm.
This is the form A. The reply is at page 777. RTI reply also says, on the close scrutiny of record, no record is available in this establishment having issued any work order to MS such and such under such and such. There is no record available in this establishment having issued completion certificate bearing number such and such against the above mentioned firm work. Earlier, the said location fell under RW Changlang, but after bifurcation, the said location under Jairampur. Thereafter, where my record was handed over. Apparently, he could not have worked there.
No record is available in the
4.4.
Not create something,
Yeah, he wants to, in any case, my lord.
it might have been misplaced or something like that,
Yes,
indicating.
yes, he doesn't want to say exactly, but the fact remains, my lord, how can he bid there? They have not responded to it in any case. And my lord, this having completed similar nature of work is a condition of contract under 4.4A B. This being a condition of contract, how can he be awarded? You reject my bid on flimsy ground. Apparently, my lord, fraud, my lord. Fraud vitiates everything, my lord. That's my humble submission. Now they are going to say that work has started now, 20%, 30% complete. But that does not, my lord, in my humble submission, my lord, where in such a situation, my lord. Sure.
Yes, that's all. Yes.
Geotech, or just I want to point out, regarding the geotech, that comes in clause 14.
Hmm.
The reason they have given for my is something else. In the affidavit, they have tried to improve. That is not permissible. My lord knows. Krishna Bhanji and the Commissioner of Bombay cases, my lord.
May I please? Well, we have explained everything in our affidavits.
Wrongly.
Not wrongly.
Wrongly
I'll submit it. 4.4B A2. In affidavit that information furnished with bid documents is true and correct. So the bidder has to submit an affidavit stating that all the documents which is submitted with bid document is all correct.
That is as per?
4.4B A2.
Let us see.
There has to file submit an affidavit. Page 45.
45.
Yes.
An affidavit. 4.4
2.
In
An
affidavit
that the information furnished with
the documents is true and correct.
in all respects, such other appendix to be failure to produce and make the bid. Yes.
The bidder has to furnish an affidavit stating that
All the documents submitted
is true and
are correct.
correct. But as per the evaluation committee, the document which he submits was not all correct.
Which one is not correct?
That in the site inspection, they have to geotech and signed by the AE or executive engineer. That is not there. There is, of course, a signature of the JE. As per the SB, it should be AE to executive. So that information, according to evaluation committee, is not correct. This is the one. Then second is 4.71 is that even if all.
What is the requirement of geotech? To submit the requirements.
No, geotech, of course, they have to submit with the site. I have visited the site.
Under which provision?
Photographs.
Which clause?
At page number 73, madam.
73.
70.
But that is not the ground they have given.
Section 14.1.
Site inspection reports.
Site inspection report.
In preparing the bid, may it is on risk rely on initial investigation.
Investigation report, if referred to encounter data supplemented by any other.
The bidder must, along with AE, JE, and certificate of same, along with bid documents. My site information report is at page 233.
Kantar signed by AE, EE, and
233.
JE also. Yes.
233.
Yes. I did not show this because the ground was something else.
Yes.
The 233.
This is by countersigned by
Junior engineer.
And it says
Junior engineer also. The bidder must
submit
submit
geotech
with
computer
EA,
software
JE.
taken along with EJEA.
it has to be Kantar signed by EE and executive.
Let us read or. then it has to be by E or A.
Countersigned by the PSC.
Yes. Yours is by J only.
By the J, yes.
Okay. Yes,
That is not there. Then,
it's the only ground.
no, there is three ground. Then another ground is 1.32.
Just
So-
wait, just read this again. An affidavit that the information furnished with the bid document is true and correct in all respects in such category as defined in everything.
This is what they use nowadays. They say, supposing I submit a wrong document,
Yes.
then they go to the affidavit saying that, oh, he said all documents are correct, but the document was not correct. That is why I'm using this. This
I don't
every
think-
RWD
At
method.
least there's a countersigned by the junior engineer.
Every
It cannot be
No, is
it cannot be strictly called as a incorrect documents. There's a omission to get the countersign by the A or the E, but it is by
the
the
photograph
J.
it has to be with JE. The bidder must submit geotech photograph of site visit taken along with EAJN certificate for the same countersigned by,
Really, the error of the tree.
they had interpreted that way.
in the minus, they never give the reason. They only come with the clause so that we get confused and file in a confused manner. And in the affidavit, they will come up with.
Next
something.
point, my lord. Next is that
So this is the,
One of
according
the-
to you,
one of the reasons, yes.
4.4B, A2,
Yes,
because of geotech.
yes. So I
Right.
submit-
Right.
Only
inspection-
counter signed by
Time
the
expense, yes, not
junior engineer.
Hmm.
It is
Not
not a
countersigned by
correct
the
document.
agency.
that's why I filed a false document and a
Hmm.
false affidavit.
Yes,
then
yes, then.
another ground is that he have participated in three packages. All the tender was at the same time. Then he has, in his bid document, he has made nil. At least he has give information that I have participated in this three.
Same day, last day is also same time.
Otherwise, it will be difficult for
Suppose
the
if he-
bid capacity also.
If he first submit in this case, and later on he decided to do the, how can you put it in advance?
No,
I mean, he may
at
not like to
at the
participate.
same time, he is participating in three. He
Yes.
knows that I am going to participate in three. I am
See,
participating.
while submitting the first one,
Yeah.
this one, he may not like to participate in the other two. Therefore, it was nil. So subsequently, I mean, maybe some later point of time, maybe the half an hour or 1 hour later, he might have decided to
That
go
is
for
the-
it. So that is,
As per the
these are all,
technical evaluation committee.
it's not, it is
Well,
all
that is the
ancillary.
finding of the technical committee.
minor
I'm
of
sorry
this
for
thing.
intruding. In fact, one of the work was awarded to me, man,
Okay,
at page 778, 78. Of the
One of
reply,
the
of my
three-
reply, yes.
out of the three works,
Yes, one was
one
awarded.
of the works has
Yes.
been
Yes.
awarded.
I
to-
surrendered it ultimately,
Okay.
but it was awarded to me, page 778
Okay.
of the reply.
Then
Why,
he-
why you are, once the work order you have, I mean, the work which you have been awarded, you have surrendered, why you are after this? Is it not the same amount?
otherwise also behind the
Is
scenes.
it higher? This is higher, amount is higher.
I was amended the work which was around 3 lakhs.
This one is,
This one is
3 crore.
83 lakhs, sorry, 83 lakhs, 88,000. That was I was awarded. This one is, my lord, just a moment.
so you are aiming for two,
Yes,
aiming for higher amount,
appears so. It is, I think, more than, 20 crore or 2 crore.
20 crore.
There is something which I cannot disclose.
Huh?
Behind the scene, there is so many, lot of things.
2 crore.
They knows. Petitioner knows.
I don't know anything.
Okay, okay.
Otherwise, my lord, the prayer.
No, you complete that. Then
Yes, I have submitted. So that as per the technical evaluation committee, these are the 3 grounds which they have not fulfilled.
first grant you have not said so. First, other 2 grants.
Yes.
First grant, it's okay, 4.4.
Yes, 4.4.
Understood that?
Then since they have made a false representation in the form of affidavit, this 4.71 attracts.
What is the false affidavit?
4.7,
What is the false? What false affidavit?
that
is?
affidavit, the countersign that was not there.
That
Then
cannot
as
be
per,
a false affidavit.
he has not furnish the other work which was participated, which he has participated as per 1.3, as per the evaluation committee, he has not furnished, he has made nil, whereas he has participated in 3 packages.
There is a ground under the 4.7.
Now that is wrong information, misleading information. That's
Hmm.
4.71 is misleading information.
Okay. Then
These are the then 1.3.2.
other one is
That is
4.
in as per close information on bid capacity. So if since he has not furnished the information that he has also participated in other packages.
Which clause?
Clause 1.3.2.
Hmm.
This clause is mainly required for calculation of bid capacity. Suppose
Section 3.
he has made nil, whereas he has participated in 3 packages.
Hmm. Works for which bids have already been
Yeah.
submitted.
Yeah. There he has made nil.
Hmm.
So suppose 3 packages he have participated, then it will be difficult for the committee to calculate the bid capacity.
Hmm.
For this purpose, only this clause is required. He has to furnish whether he participated in other packages also. That is the 3 grounds which the bid, technical bids of the petitioner was rejected.
Works for which bids have already been submitted. So according to you, since he has participated
3 packages.
other 2 bids,
Yes.
in the other 2 tenders,
Yes.
they have filed a false affidavit.
Yeah.
Huh? Since they have said under this clause, he said nil. He has not
Yes, he has
shown
submitted
anything,
nil. Whereas he has
whereas
participated.
he has participated, therefore. it's
That
a false-
information he has to show.
This information is false, which amounts to be
Yes, yes, yes.
a false statement.
Yes.
Okay.
That information has to be furnished.
I mean, meeting I have said it.
Yes. And that they have admitted that they have made nil. So there are 3 grounds, which is reasonable. There is reasonable grounds for rejection of the technical bids, according to me. Then my lord, even in the prayer,
But 4.4 this BA2, I'm not convinced. See, requirement was countersigned by the E or AE. And he's got the requirement under,
that also cover even
it cannot be false.
possible also
True and-
cover 1.32 also. We have not submitted, furnished the information regarding participation of 2 others bids.
Okay.
That
They
is
have to
also misinformation, wrong
They
information.
have to be sure about which they are saying that, which document.
Yes.
Then my lord, in the prayer, they have Guas and set aside the impugn minus of technical bid evaluation and minus financial evaluation. After this, the work has been about, agreement has been already drawn and work is started at this stage. And he has not stated that the Quasi set aside and Quas the technical bids of the successful bidders. His prayer is that there should be a fresh NIT. That is only 2 prayer which they have made. Now the work has been awarded to successful leaders. And work has been progressed substantially at this stage. Well, even if there is some aberration or some
Jagdish Mandal.
by the yes, by the tender evaluation committee, this court should not interfere because this is a public infrastructure development activity since it's school building. So it's a public interest project. Moreover, work is progress rapidly. So
How many months now?
now almost 2 to 3 months, I think 3 months.
What is
Now,
the-
as far as we
what
have,
is the period of completion?
we have already in my affidavit, there is a photograph.
We are not interested in photographs.
There is photographs countersigned by the engineers concerned executive.
Then we are not interested in photographs.
My lord can,
Just wanted
that
to,
restriction can also be done.
just wanted to point out one thing.
Hmm.
What my learned friend is saying is this because of the site inspection report. That was a false document, a 4.4B. We have filed additional affidavit after we're directed to file all the documents of all the three packages. We have filed it.
Hmm.
In one of the additional affidavit, your lordship will see it is the exact site inspection report I gave in respect of the work I was awarded. How can that be a ground? Same committee. Counter-assignment, same man. Same report. It's on record, man.
The private respondents is also participate in the tender where in
That I'm
which
not aware.
you have been
That I'm not aware.
awarded.
That I'm not aware. At page 537 of my additional affidavit, it is the same site inspection report. It's only junior engineer. In that manner, if that ground is not a ground for rejection, how can in the other package it can be a ground for rejection?
So my lord, my humble submission.
How do you decide 4.7?
4.7.
You said it was same day, same tender, I mean, same time.
Hmm.
So you have done it after submission of this tender, according
Yes.
to you. Therefore, there was a need. You have
Yes,
to-
need. On the same day I have submitted, so there was nothing pending.
Ah.
It says pending bits. There was nothing pending. So I says nil. I'm admitting it, my lord. Assuming I'm admitting it, I leave it to your lordship, my lord. That is my understanding. That is my humble understanding. And it was open on the same day, my lord. That is my humble understanding. And apparently, my lord, they have awarded to someone
Who is not eligible,
not
qualified.
Dayaram
Who do
Shetty, my
on
lord,
the
comes
basis
into
of
play.
the force document.
Yes, Dayaram Shetty comes into play, man.
Hmm?
Dayaram Shetty, my lord,
Oh.
directly comes into.
My lord, that is the, since work has progressed, so there is, if he has really agreed by the decision of the technical evaluation committee, he has other alternative remedies which he can sort.
What is the alternative remedy?
He can go for a civil suit. Then since this is a infrastructure development works,
Hmm.
so at the cost of the unsuccessful leaders, public interest should not be hampered.
Hmm.
So even if there is some average and even there is no any allegation of malafide action.
Hmm.
So this is my humble submission is this court need not interfere.
Hmm.
So this is my prayer.
Your private respondent.
Yes, my lord. My lord, may I please, this page 63, my lord,
Hmm.
of the writ petition.
Ah.
My lord, section 3, my lord, which your honor was, your lordship was reading, my lord. Page 63, my lord.
Hmm.
The information, my lord, the first one, section 3. The information to be filled in by the bidders in the following pages will be used for purposes of post-qualification, my lord, as provided for in clause 4 of instruction to bidders.
Hmm.
So, my lord, now, my lord, B, my lord, 1.3.2B, my lord. Now, they have submitted, my lord, for works for which bids have already been submitted. They have admitted in their para 11, 12, my lord, that they have written nil, my lord. Now, this section 3, my lord, what it, my lord, what postulates, my lord, for post qualification, my lord,
Hmm.
to see whether he would be financially sound, my lord, to perform the work, my lord. That is my understanding, my lord. On the top, my lord, the information to be filled in by the bidders in the following pages will be used for purposes of post qualification, my lord.
Hmm.
So, my lord, that is to be seen by the authorities whether the person would be eligible, would be financially sound to execute the work, my lord. Because he has to submit, my lord, whether he has submitted bids in under tender or not. So they have admittedly submitted, my lord, that they have submitted 3 bids, my lord. And in another 2 tenders, my lord, they have submitted bids.
Hmm.
Now, my lord, we cannot say here, my lord, which was submitted whether, when, my lord. Whether the first one was for other tender, whether the first one was
If you
submitted.
cannot say that they say they have submitted this one is, they first submitted this, therefore, when they submitted this tender,
My lord.
bid in this tender,
Right.
in this case, they have no pending bids.
From my
So you
understanding.
will have to say that, no, there was already pending bids.
My lord. But, my
Therefore,
lord,
it's a false system, information.
my lord, that is the
If
interpretation
you
of the,
cannot say, will accept the submission of the petitioner.
my lord, what I am submitting is, my lord,
Hmm.
they have to furnish, my lord. They have to disclose, my lord, whether they have submitted another bids or in other.
They have
tenders.
not submitted.
But, my lord, they have admitted in their
No,
panel 11.
ultimately they have participated. But
Yes, my lord.
when it was same date, same time, so there was no pending when they submitted this tender.
So other two bids submitted by the petitioner can be taken as a pending, my lord, this.
So we'll have to see at what time, what point of time, what is the exact time of the submission? Should we go into all these things?
My lord.
Anyway,
My lord,
next.
may, my lord.
Hmm.
Now, my lord, this page. Rejection of bid, my lord.
Hmm.
The impugn order, my lord.
Hmm.
Let me kindly come to page 27, my lord.
27.
Yes, my lord.
Hmm.
The technical evaluation, my lord.
Hmm.
By this evaluation, my lord, this is the impugn technical bid evaluation, my lord. The bid of the petitioner was rejected, my lord.
Hmm. Who is disputing this?
My lord, they are not challenging this, my lord, this rejection order, my lord.
Hmm.
They are not challenging rejection of this technical bid. My lord, may please come to prayer, my lord. Page 17, my lord.
We have seen it.
Of the
We have
petition,
seen
my
it.
lord.
Yes.
My lord, they are not challenging rejection of their technical bid, meaning they have admitted, my lord. They have accepted rejection of the technical bid. They are challenging the entire tender process, my lord.
Huh?
They are challenging the entire tender process without challenging rejection of the technical bid, my lord.
Question set aside the impugn minutes of the technical bid evaluation and minutes of both.
Not his rejection, my lord. Not
Huh?
his rejection. He is not challenging rejection of his technical bid, my lord. He has to challenge rejection of his technical bid, my lord.
Hmm.
Then he can, if he is allowed, my lord, then he can participate now and then he can challenge the tender process, my lord. Now that his technical bid has been rejected, my lord,
Okay.
and he has admitted it, my lord. Now he has no locus standi, my lord,
Hmm.
to challenge the entire tender process, my lord.
If he is not rejected, what is the question of challenging?
Yes, so, my
Had he
lord,
not been rejected, who will?
in
will-
that
will
eventuality, my lord, my answer is, my lord, in that eventuality, he should have challenged his rejection of technical bid,
Okay.
not the entire technical evaluation
Hmm.
report, my lord.
Hmm.
So, my lord, what I am saying, my lord, he has no locus.
Tell us, I've understood, Locus, forget about it. Come to the merit. How you can obtain a completion certificate in 2000, 1 year before you become a contractor?
My lord, I have completed, my lord.
And that too from a different district. You are from which district?
I am from Lower Siam.
How you will allowed to participate in the distant district?
My lord, then page 1716, my lord. It does not say that I have not.
Also, when you become a contractor, enlisted contractor in 2021, how the completion certificate can be obtained in 1 year before?
Yes, my lord. This is, my lord, I can do, my lord, work. How can I collect the work? How can I obtain the work? It is up to me, my lord.
No. That's the problem.
I have executed the work.
If you are up to, it is up to you in contrary to the requirements of the rule. That cannot be permitted. You can do anything.
But I have executed the work, my lord.
You might have executed when you are not entitled, when you are not become a, who has given you the work? How your work has been given?
But it is
How the work was awarded?
by the, my lord, executive engineer. They have annexed, my lord. Yes.
And the executive engineer said that there is no record.
No, my lord, may I repeat? There is no record available in this establishment having issued completion certificate bearing number so and so dated Changlang the 20 May 2020 against the above mentioned firm and work.
Where are
Earlier,
two?
the
Where are
said
two?
location fails under
I
RWD
have
Changlang
read
division.
it.
But after bifurcation, the
Sir,
said
I have
location.
mentioned it, I have indicated to the
Yes, ma'am.
petitioner also.
So this RTA information does not disclose that I have not executed the work.
How you can execute when you became a contractor in 2000, enlisted contractor in 2001?
Yes, ma'am. I was class 4 at that point of time. Ma'am.
Hmm?
I was contractor, ma'am. It is not that I was not a contractor, ma'am, but I have executed the work, ma'am,
Of what amount?
of 2 crore, ma'am.
As a class 4.
Yes, ma'am.
As a class 4.
Yes, ma'am.
What this rule says? Entrepreneurship Act, what does it say?
Well, rules may say that yes, but of course, my execution of work has to be appreciated.
Hard to believe.
Ma'am,
See, I understand you can do whatever,
yes, ma'am.
but if it is not done as per the requirement of the rules and the provisions of the law, how it will have any validity?
My lord, if I suppose I say, my lord, I am from Papumpari. I got the work from,
That's why I say
It's coming,
it's
my lord.
illegal, that cannot be accepted.
but I have executed the work, my lord.
We don't know, but there's a certain norms,
Right.
rules and regulations, right? There's a rule of law in this country, I believe.
My lord.
So,
Otherwise also, my lord, I will come into it, my lord. Part by part, I will come to it, my lord. I will address to it, my lord.
what you address now,
But I would like to submit, my lord. I would like to complete my submission, my lord, first, my lord.
yes,
Yes, my lord. My lord, in the entire writ petition, my lord, there is no whisper
I'm
regarding.
not interested in technicalities.
My lord. But-
Unless it really goes to the root of the matter.
My lord, our High Court, my lord, division bench has said, my lord, a person whose technical bid has been rejected, my lord, he cannot challenge the tender process, my lord.
Then who will challenge that?
My lord, he cannot challenge. He has no locus, my lord.
No, who will challenge that?
The other bidder,
If
my
the
lord,
technical bid is not rejected.
rejected.
If his technical bid
Is not
accepted,
rejected, my lord. Yes,
Huh?
if accepted, my lord, he can challenge.
that
But
will be-
if his technical bid has been rejected, my lord, he cannot challenge, my lord.
Sir, that will be ulta.
My
It's
lord,
upside down.
I have a judgment of our division bench, my lord.
Huh?
Our division bench has said, my lord. Yeah, my lord. My lord- my lord, may please come to my affidavit, my lord.
So according to you, if bidder is accepted, only they can file a writ petition.
Yes, my lord.
If his technical bid is rejected, he cannot. He
Yes,
has not.
he has to challenge his rejection, my lord.
Huh.
He has to challenge his rejection first, my lord.
Huh.
And
Then-
then, my lord, if his bid has been allowed, my lord, then he comes to the process, my lord. Then he can challenge the tender process. Not now, my lord, because his bid, my lord, has been rejected by the tender board, my lord. He is
Yes.
not in the process now.
Yes.
So since he is not in the process, my lord, he cannot challenge the tender process. He has to first enter in the tender process, my lord.
He has submitted the bid.
Yes, my lord.
His technical bid
Has been rejected, my lord, yes. Now he is, by way of this writ petition, he is not challenging rejection of his technical bid, my lord.
What the order the
He
player
is
say?
challenging rejection of, my lord, he is challenging the entire tender process, my lord, entire technical bid evolution, my lord.
Yes.
No, my lord, it cannot be, my lord. This is my humble understanding, my lord.
If that is your understanding, I'm sorry.
My lord. My lord, my affidavit, my lord. Page 793, my lord. Of respondent number 6, my lord.
This one. Or two in this one. Mhm. This one. Which, 7?
It starts with page 779, my lord. affidavit in opposition filed by respondent.
Yes.
Yes. 779. Now.
Hmm.
Now, my lord, may I please come to page 793, my lord.
Hmm. $793. Yes.
Yes, ma'am. This affidavit was filed on 2nd June 2025, my lord.
Hmm.
My lord, this letter of acceptance, my lord, was issued on 20 March 2025 in my favor, my lord.
Hmm.
And then, my lord, page 794, my lord.
Hmm.
Agreement was entered between the authorities and the private respondent, my lord. Me, my lord.
Who is disputing all this?
Now, this would be relevant for me, my lord,
But
in my case, my lord. And then 796, my lord,
no one is disputing that work has been awarded to you.
my lord.
The issue is how it has been awarded, legally or validly.
My lord, first,
First, well, we are considering about the rejection of his technical bid.
my lord.
Then next will be how you have been awarded. We'll see.
But
The
my
first, according to you, since the petitioner has not challenged the rejection of his technical bid,
rejection of his technical bid.
only his challenge is only the entire
Technical bid
technical
evaluation, financial bid,
evaluation and financial evaluation.
my lord.
Therefore, he is no.
He is no
doesn't
locus,
have
my
the
lord.
locus.
Yes, ma'am.
The number two.
Number two, my lord,
Second is
my lord, it is admitted, my lord, by the respondent or by the petitioner that, my lord, they have
participated. There were two
other
pending bids, which he has
Tenders, ma'am. Yes, sir.
which he has filed a false affidavit
Yes, my lord.
saying that there is none.
Yes, my lord.
Right.
Yes, my lord. So author would be the best person to interpret, my lord.
Then third,
My lord, I have been also paid bills, my lord. I want to show, my lord.
I'm not interested on that.
My lord.
Third.
My lord, may I please come to my additional affidavit, my lord.
So many additional affidavits.
Yes, my lord.
This page 816.
My lord, yes.
Page 816.
Additional affidavit of respondent number 6, my lord.
Yes. 816.
Yes, my lord. My lord, may I please come to annexure, my lord. 8, my lord. My lord, there is an office memorandum issued by the principal, my lord, secretary, my lord, PWD, my lord, who has issued the, my lord, registration certificate to us, my lord. Now it says, my lord, the local contractors are exempted, my lord, from furnishing, my lord, is work experience, my lord, tools and plans and technical staffs, my lord. This is of 2023, my lord.
So you are otherwise indirectly admitting that the completion certificate.
No,
which you
otherwise
have-
also, my lord.
which you have relied and submitted is a forged one.
No, my lord.
Then-
What I am submitting is by virtue of this office memorandum, my lord, the petitioner has no cause of action against me, my lord. The petitioner, by virtue of this office memorandum, my lord, the petitioner has no cause of action against.
I would like to know where in the jurisdiction. Would like to know. You said you can do whatever.
No, my lord.
That will not allow.
No, my lord. I can get a work, my lord, some way or other, my lord.
In
But I have
accordance-
executed
in
the work,
accordance with the norms, rules and act,
my lord. But
Right.
I have executed the work, my lord.
not by your muscle power
Not by, my
or
lord.
by bullet
I
power.
cannot show my muscle power in Changlang, my lord.
Hmm?
I cannot show my muscle power in Changlang,
That's the worry. That is the irony,
my lord.
which clearly indicates.
Let me clear. I was instructed by executive in the 2019. He was class 4 contractor. Then during that relevant point of time, he executed some subcontract work. That was, I thought he will bring all this record, but he has not. Then after cancellation of class 4, then he has been granted class 3 contractor into 2021.
From where you are getting all this thing?
That my verbal instruction.
Huh?
Instruction, verbal instruction that was given to
You
me.
bring the records in that case.
My lord,
Part hard.
my lord, regarding the locus, my lord,
Only just, only for production, the record one, keeping it.
only for the locus, my lord.
Huh.
I would like some.
Why not interested in law?
Class 4 contractor.
He has no locus, my lord, read petition is not mentioned. my lord.
We'll record the submission, but I'm not interested.
My lord, same facts, my lord. Same facts. My lord, there are three, my lord. Appellant's counsel, my lord. Appellant's counsel submits that the appellant participated in selection process for construction of works in pursuance to NIT data so and so, whereas so and so. The present appellant relates to package number so and so with an estimate cost of rupees so and so. The appellant writ petition technical bid has been rejected by the state respondent as his bid did not conform to the terms and conditions of special so and so, my lord. He submits that respondent number 6, my lord, was not eligible. So in my case, my lord, was not eligible to participate in selection process in view of the provision of so and so, and
Where's
whose plan there under.
the provision?
District based Arunachal Pradesh.
Ah.
District based,
Where you are
So-
reading? Where you are reading?
Second page, my lord, next page of para 3, my lord. He submits that though the respondent number 6,
Because the
Second.
appeal position technical may have been rejected, still as well as it did not conform to the terms and conditions of so and so. He submits that though the issue was not eligible to participate in selection process and the responsibility had been selected as successful independent body. Yes.
yes,
Then?
my lord. Now, para 4, my lord. The appellant's counsel submits that the selection of the respondent 6 should be set aside, my lord. He also submits that the rejection of the appellant's technical bid by the state respondents for the contract in question should be set aside, as the same was not justified, my lord. Para 5, my lord. The learned counsel for the respondent, on the other hand, submits that the appellant's tender has been rejected as he did not fulfill the terms and conditions of the NIT. And accordingly, the appellant does not have any ground to challenge the selection of respondent number 6 as the successful tenderer. The learned counsel for the respondent 6 submits that at this stage, 95% of the work has been completed, and as such, it would not be justified to interfere with the development work that is going on, my lord. Now, my lord, may come to please, para 11 and 12, my lord.
You're just right. You should, petition not having fulfilled the terms, so and so, huh? Para?
11 and 12, my lord.
Huh.
This is the, my lord, relevant portion. In the case of Roanoke International, my lord, so and so, the apex court was to decide whether the appellant fulfilled the qualifying criteria for implementation of the contract work. However, the challenger, the respondent, also did not fulfill the qualifying criteria. The apex court thus held. Therefore, any judicial review at the instance of a party which does not fulfill the requisite criteria seems to be misplaced. Para 12, my lord. In the present case, the appellant's tender have been rejected at the threshold due to non-compliance with the terms and conditions of the NIT. The appellant has no locus standi to challenge the selection of respondent number 6 as a successful tenderer. Further, it is not disputed by the parties that contract work has already been started. We do not find any ground to interfere with the implement.
That's why you have wrongly understood this.
Yes.
Though the word has been used locust, you just cannot locust to file a writ petition. It was found in this case
My lord.
that the
No,
appellant has not
And-
fulfilled any the criteria of the tender.
My lord.
Therefore, he cannot claim as a.
So, my lord, he is not challenging his rejection of technical bid. What I am submitting, my lord. He is not challenging his rejection of technical bid. He is challenging entire tender process.
What more he will say that these are the criteria on the ground which he has been rejected. It's not correct. That is one day he's saying.
Yes.
And he said accordingly prayer is has been made to citizen quash the technical and financial bid.
My lord, he should first challenge his rejection of technical bid, my lord.
You have misread the judgment.
Yes.
Roanoke
What
International
it
is
doesn't
not-
mean that no, what you are trying to project is we cannot look into because it doesn't know locus.
Yes, my lord.
It's not that. Here is a case, the court found that the appellant has not fulfilled the criteria of the tender project.
So,
We're examining whether he has
Yes.
fulfilled or not. The clauses under the clauses
Under which
under
I
which
rejected.
the petitioner has been rejected, whether it is genuinely rejected,
Yes.
validly rejected, or wrongly rejected, we're examining.
Yes,
We
my
will
lord.
stop that.
They-
There's a question of locus.
now what I am submitting, my lord, that is the question that has to be before this honorable court. But
We're
it is not the
we're
question here, my
fixing
lord.
it some other. You read it.
My
and
lord, it
again.
is not the
You
question
read
here,
it
my lord.
again. You
My
read
lord, my lord.
You
Now, what I am
again, you again read it
My lord,
and come back.
my lord,
Give it to him.
my lord, what I am submitting, my lord, is that he is out of the race, my lord.
Obviously.
So why, my lord?
What
He-
you are, sorry, what you are trying to submit is that since his tender has been rejected, he doesn't have a locus to file any writ petition. That is what you are trying to.
Yes, my lord.
Case number
First,
W.
my lord,
So
he
what
should-
I am saying is, if his tender is not rejected,
WA 44.
how he will file, how will challenge the, for what he will file a writ petition?
my lord, he should challenge rejection of his technical bid, my lord, not the entire tender process, my lord. That is my submission, my lord.
Are sir, I said he has challenged.
That is wrong, my lord. That is why I am submitting. my lord. Now, what I am submitting, writ is not maintainable, my lord.
No, it's okay, I will accept that, but read the judgment again and again.
My lord, my lord.
And including Ronak International.
My lord.
There is some other judgment also. Read it again and again. Come back.
My lord, this interpretation, my lord, what my lord, understand, my lord, is
That's
that,
why I want you to read it again.
my lord,
You place the records
My lord,
with regard to his credentials. We'll see.
transport contractors,
Hmm.
that is not part of tender. program. That was read during.
That is.
You have
my lord,
relied, you
that
have,
itself shows.
have you relied on the completion certificate? The credential, whatever, it is for what? Completion certificate is for what? Similar type of work. You have relied his certificate?
Yes.
Yes, what he is trying to, now by filing the additional affidavit, he is trying to disown. This is not required.
What?
Whether you have relied on this certificate or not.
That document is.
Of course they have relied. They have
But it
relied.
was for contractors.
Hmm.
During 2029.
That itself shows.
2029,
2019.
2019.
That was,
Huh.
he was class 4 contractor. What? The respondent has told to the.
Huh.
executive engineer.
Hmm.
In any case, 4, 5, he could not have participated.
No, whether you have relied on these documents, the page, what is documents? Page, huh.
Yes, they have relied on, they have not responded to it. Yeah, they have relied.
Because it is one of the condition,
Then I,
one of the requirements in the tender.
Yes, what
The
requirement?
similar nature of work has to be furnished. You have relied on it.
they might agree that they have.
That's why I want to go into it.
They have relied, my lord.
my lord, I will read para 12 again, my lord.
Huh?
Para 12, my lord.
Read
of
it.
this judgment. Yes, my lord. In the present case, my lord.
You go back and have,
My lord, yes, my lord, of course, but
Make
I would
your
like to
mind-
satisfy your.
make your
your lord.
mind cool
Yes, my lord.
and read the Ronak International also.
My lord, the para 12, my lord, the interpretation, my lord.
Hmm.
Para 12, my lord.
Hmm.
In the present case, the appellant's tender having been rejected at the threshold due to non-compliance with terms and conditions of the
Not
NIT.
due to
Now-
non-compliance.
Yes,
We are yet to find out.
That is why, my lord.
decide whether this is, whether this
Now,
has been,
before deciding that, my lord, whether he can challenge the entire tender process, my lord, that is the question, my lord.
that is not the question.
My lord.
Your understanding of judgment is completely fallacious.
My
Give it.
my lord.
So can you,
No record.
can you produce the record?
That record registration will be with you.
Huh?
Then,
No,
No, you tender no records.
Tender
or
records,
tender record, okay.
both the, we'll keep it part heard. We may not, if any query is there, I may. The court may make the query, but then
Yes.
almost I have heard.
My lord, I have to submit more, my lord. I have some judgment, my lord.
Keep it yourself.
My lord, our division bench says, my lord, there
You
are,
do one thing.
my lord,
You do one thing.
my lord,
You compile, you submit a compilation
my lord,
of all those judgments.
my lord,
It may enlighten this court also.
my lord.
Hmm. But properly read it and compile it and submit.
My lord.
I'm allowing it with on the condition that if I find that you have misread the judgment, you have misunderstood the judgment, I'll impose a cost on you.
My lord, I would like to read para 12 again, my lord.
My learned friend says he can produce a record on 23rd.
Huh. 23rd. Huh.
Part.
Heard, mister. Are you satisfied? You want to argue more?
My lord,
Let
yes,
us
my
argue
lord.
on 23rd.
My lord. Because I have executed the work, my lord.
Okay, 23rd.
Yeah.
23rd on, I'll give you 15 minutes. Heard Mr. D. Pangi, learned counsel for the petitioner. And also heard Mr. G. Tarak, learned standing counsel RWD. For respondent, you find it honor from the petition. As well, and Mr. B. Pitcher, learned counsel for respondent number 6, huh?
Yes.
1 to 6, I think 1 to 5. You are representing 1 to 5. Method, the parties, learned counsel for the, hardly learned counsel for the parties at length. List the matter. However, please, huh? List the matter on 23rd, so and so, huh? On which date, comma, on which date Mr. G. Tarak, standing counsel shall produce the record. Okay.
What the petitioner and respondent.
Huh?
General record. Problem.
It's okay, my lord.
Huh? 15 minutes on
30 minutes,
23rd.
my lord.
Huh?
30 minutes, my lord.
What about the other cases? How many hours do you have in a day?
No, my lord.
Morning 2 hours, evening 2 hours, afternoon 2 hours, 4 hours. If you take one matter, 30 minutes, that too private respondent,
My lord.
not even a petitioner.
Because now substantially I have invested, my lord.
Let us be very practical.
My lord.
Let us change the system.
My lord.
I mean, let us progress in a progressive manner.
My lord.
Develop ourselves.
My lord. Obliged.
What is this?
Your Lordship,
Yes.
here in this case, respondent number 2 and 3, they haven't filed their affidavit yet.
Yes.
My lordship, we need some more time, lordship.
Hard central and concept for the, on the prayer of Miss MS K. Wangba, London State Council for the 3 weeks.
Yes, ma'am.
3 weeks time is granted.
Lordship,
to
one
file affidavit in
prayer,
office.
Your Lordship. This matter has been pending since 2021.
Yes,
So
I've seen it. You are for? You have filed the affidavit.
Your Lordship, kindly it may be made sure that on the next
Mr.
occasion,
K. Lawyer Learned Council for the petition, respondent number 6. Submits that he has already filed the affidavit on behalf of respondent number 6. List after 3 weeks.
Lordship, it may be made sure that on the next occasion, they may file their affidavit. It may be made sure.
Hmm?
Yes, it may be made sure that they may file their affidavit
Yes,
on the.
be sure.
Yes. Obliged.
Yes.
Your Honor, I am for the respondent number 2.
Ah.
I'm the LAC here. I am yet to file my reply.
You want some time?
Yes, Your Honor.
And who is for the petitioner?
I'm for the petitioner.
How do Mr. So-and-so learn counsel for the petitioner? On the, you have filed the affidavit?
Yes, they have.
MS K. Wangbo, London, the State Council submits that she has already filed the affidavit on behalf of the state. Mr. Next para, Miss S.B. Daran, counsel appearing on behalf of respondent number 2.
Yes, respondent number 2.
Fresh
private
for and is granted for the 3 weeks time to file affidavit, to file her response. 3 weeks, after 3 weeks.
Yes, most of them.
Yes,
Here, my lord,
affidavit in opposition filed.
my lord,
Yes,
one thing is there, my lord, respondent number 3, my lord.
3.
Yes, my lord, has been inadvertently, my lord, made as party respondent, my lord.
Respondent number 3.
has been made inadvertently made park correspondent, my lord. So, my lord, I may be allowed to,
National Highway,
yes, my lord, that
is there not,
in his place, my lord, I may be allowed to implement grip, my lord.
huh?
BRO.
You file an application?
Yes, my lord, I'll file.
Yes, Mr. L. Norsi, London Council for the petitioners submitted, press for 2 weeks time to file approve, record application for striking out of the response number 3 and for implement and also for implement of the necessary party. Praise the Lord. This stuff for you record your name. Is it required?
Respondent number 3.
Okay. Are present. You just say are present. Then additional advocate general and Mr. President for respondent. Yes.
My lordship.
Ah.
Lordship, this is my first appearance, lordship. I am for private respondent number 5 to 9 and 12 to 18, lordship. I filed my wakalat number this morning and I need 3 weeks
Respondent
time.
number
5 to 9 and 12 to 18, lordship.
5 to 9, 12 to 18. Then rest. Rester
I repeat on behalf of
1 and 2. What about the others?
Others, I have no idea, Your Lordship, but the notice has been.
Office note, Mr. Ketan, office next, office note dated 17/06/2025 indicates that ID card has not been received in respect of respondent 3 to 18. Mr.
Okay, lordship.
London Council for the London Council submits that London Council enters affairs on behalf of respondent number
Respondent number 5 to 9 and
5 to 9
12 to 18.
and 12 to 18. Mr. Therefore, no further steps is required to be taken. Mr. The London Council for the petitioners to take its steps. You take precise steps for remaining respondents. You just count it and put it there. Huh? In that case, respondent number 3, 4, 10, 3, 4, and 10.
11 also, lordship.
11.
Yes.
You are 4, 5 to 9.
5 to 9 and 12 to 18.
Then in that case, to take its precise, you take precise steps.
Yes, Your Lordship.
It's been long time. Mr. 1 and 2, the Learned Council for them. Have you change your name?
No.
What should I record? T Gade.
Right now, T.
Huh?
T. Gade.
Okay. T Gade.
Your Lordship. I may be allowed justice service also.
As well as, as usual process, as well as by dusty mode. Respondent number 4, 3, 4, 10, 11. 4 of them.
Yes, Your Lordship. Oblige, Your Lordship.
No light.
Yes.
Lordship, step has been already taken.
AWS service report, list after 3 weeks.
All answers.
Whatever.
Hello. My lord, I have filed an IAOA under Article 226(3) of the Constitution, my lord. It has
Or
been
what?
pending for over 4 weeks. My lord, we are the executing agency of a project which is of national importance. And the petitioner herein is one of the landowners. Supposedly he came and he got an ex parte interim stay against my further construction. Now, my lord, as per the existing law, I am exercising powers under the Telegraph Authority. My lord is well aware, while exercising powers under the Telegraph Authority, my lord, I have come with a set route alignment and based on which I am doing my construction work.
Yes.
So, my lord, my prayer is the IMA be heard today.
Now we'll dispose of the entire matter.
May I please, Lordship?
I have
Lordship,
law-
before my learned colleagues submit, Lordship, may I pray that this matter may be taken up for final disposal on 24th, because I have to file a rejoinder to their affidavit in opposition.
Fair enough. 24.
24th.
My lord,
And for final disposal,
my
Lordship.
lord, if I can just, my.
No.
I want to-
We'll go for this thing unnecessary. Once we suppose if we accept, you may be ground for vacation. Once we accept that, it will become infructuous.
My lord.
Yes. And I-30 they have filed.
What is
from-
the interim order?
My lord,
Status quo, Lordship, with regards to erection of tower.
12,325, my lord.
So what do we want?
Lordship,
We want a compensation.
Lordship, no, Lordship, I want that proposed alignment to be deviated to some other place.
How you can do that?
Lordship, that was the issue here. So I'll just, because there are certain allegations against me. So I need to clarify.
How you can say that? How you can dictate terms that it should be? If it is your land,
Lordship,
if it has been acquired, it should be this, as per the law, you will be entitled.
yes, Lordship. So Lordship, this may be heard on 24th, Lordship. In the meantime, I'll.
Yes, 34 will dispose the entire matter.
My lord, I write in IA 130
My
For
lord.
what?
for striking out. I'm not a necessary party, my lord. This may be taken up.
Item
IA
30.
130.
Item
Notice.
I 130.
IA 130 in the main,
More limited is what?
my lord.
Item 30.
I'm not a necessary party, my lord.
Yes, what do you say?
Lordship, I do not have any objection.
Okay,
130 may be disposed of. IA 130.
okay.
My lord,
Hmm.
my lord, there is a submission I would like to make. If my lord can come to my IA.
Sir, I have understood. We'll take it up for final disposal on 24.
24.
Let him file whatever affidavit he wants to file.
Because my lord, we have
And
been
with
calling
regards-
them to come for the assessment. It is
Ah.
on record. They have challenged that whole notice.
24 will dismiss. Writ petition will be dismissed.
IA 130, my lord.
Not Mr. 130, I'm disposing 130. Your, this will be taken up, I will be taken up along with this. Heard Mr. H.K. Jama, learned consent for the applicant. By filing this application, the petition, the applicant who is added as respondent number 3 in the connected writ petition,
Yes.
being WPC
100.
100, so and so. Has prayed for striking of his name, striking from the writ petition, the area of parties, striking the name of the applicant from the area of parties. You are not necessary party. Why? Who you are?
I am a contractor of the PGCIL.
Okay.
Their main allegation is against the PGCIL for damages as well as for the
Mr. You write in that case, I heard Mr. S.K. Jammu and then also this A Tata applicant and A Tata for opposite party of the writ petitioner and those 3 of them. Learned additional AG and then your name please?
And Kerala.
And Khera, my lord.
N. Kera also and so.
Respondent number 4, power grid.
Then you write that, application. Next one, Mr. S.K. Jammu, Land Council. For applicant submits that. The applicant who has been added as respondent number 3 in the connected writ petition, in the writ petition, is a contractor of
PGCIL
PGCIL,
in terms of the agreement dated Annexure 2, my lord.
the Power Grid Corporation of India Limited,
My lord.
and there's no grievance raised against the applicant, Mr. Therefore, the applicant is not a necessary party. And as such, the name of the applicant maybe struck up of the writ petition. Next one. The Mr. A. Tatak led counsel for the opposite party of the respondent, the writ petitioner, as well as all of them. Learned edition is so and the Nkera so and so. Have submitted that they would not have any objection as the applicant is not a necessary party. Mr. Next, having considered the submissions and considering that of the land council parties and considering that the applicant appears to be not a necessary party, as he is only the contractor of the respondent number 4. Respondent, and then only respondent number, contractor of the Power Grid Corporation of India Limited, who has been added as respondent number 4 in the writ petition. And there's no grievance raised against the applicant. I'm inclined to allow this application, which will accordingly the name of the applicant, namely so and so, is hereby still struck off from the area of parties in connected with this. I still
Highly obliged.
and this call.
Deeply
In writ petition,
I
as
agree
agreed, also uses all of them. Record heard so and so, so and so. As agreed to by the land council for the parties, list this matter on 24
for final.
24/06/2024. 26. Mr. In the meantime, the Mr. A. Tata, land council for the petitioner may file affidavit in reply.
My lordship,
List accordingly.
we have also challenged the maintainability of this petition.
Hmm.
It may come up in the admission stage only on 24th.
Obviously.
Yes. So yes,
Admission,
I-
Yes,
Interim may be continued, Lordship.
interim order plus the list will continue.
Deeply obliged.
Yes, next.
My lord, in the last,
Answer notice.
my lord, in the last order, it was recorded that interim will be considered in the next day. This morning, interim was to be considered today, my lord, but in the
First, it has to be served, sir.
my lord, yeah. Then
Interim prayers shall be considered. What is the matter?
it is regarding, my lord,
You have to check up the record, as per the office note.
yes, we have
Have you
gone,
seen the office note?
my lord, we have gone through it. So then
So other day, will next, what is the matter?
a matter is, my lord, it is regarding upgradation, my lord,
Okay.
upgradation of this post
Hmm.
and along with upgradation of the incumbent, my lord,
Okay.
without following the recruitment rule, thereby disturbing the ratio, upsetting the ratio of the post of cadre of assistant engineer, my lord.
Okay.
They have upset the normal ratio, my lord, with their illegally upgrading
Hmm.
the incumbents from junior engineers, my lord.
Hmm.
Again, illegally upgrading the assistant engineers to the post of.
So what is your prayer, interim prayer?
My prayer was, my lord, after upgradation, my lord, after upgradation, they have already disturbed, but 38 posts, my lord, 38 posts accrued in the 2024, my lord, in the 2024. So that should be in normal course of action, my lord, that should be 50-50, my lord, as per recruitment rule, my lord. Assistant engineer assistant engineer
It's very
recruitment.
difficult to state a selection process. We'll see.
My
We'll
lord,
see.
my lord.
Heard Mr. Tijabo, learned counsel for the petitioners. How many? One, two?
One petitioner, my lord. Earlier, there were 12 petitioners, my lord, but
Okay.
now only one is left.
And also had MS P. Pango, learned counsel for the, then state counsel for respondents. Office note dated 17/06/25 reflects that counsel noted in respect of respondent number 23, 24, 30, 32, 34, 37 to and 37, 51. You check it from here. Office note has been received back. And the and in respect of respondent number 8, 10 to 22, 25 to 29, all are still awaited. Mr. In view of the petitioner to take steps for to take steps for notice upon service of notice upon respondent number. Is who's the service? 23, 24, so and so, huh? This after 4 weeks.
My lord,
What you will do?
uh,
You'll take a press steps because
Yes, my lord, we will take a press step, but my lord.
received answer.
My lord, and my lord, my liberty may be kept, my lord.
Huh?
Next date, interim may be considered.
Obviously, this is the order already.
My
We're not changing it.
Okay, okay.
Oblige, your lordship.
Yes. Yeah.
I was supposed to take a step to the private respondent, my lord, to paper publication, my lord.
Okay.
But I could not take it.
On
my-
the prayer of Mr. L. Periman, learned counsel for the petitioners, further 2 weeks' time is granted to take steps as directed by this, as allowed by this court
On my lord.
Beyond
by an order.
21
by
five.
this court,
21/5.
by an order. By an order dated 21/05/2025, Mr. Swenche. In written learned edition advocacy is approved. Yeah. Yes.
Oblige.
All that.
My lord, this is the land dispute between
Service
Petition-
report
petition-
inspection number 7 to 14 are.
petitioner and respondent number 14.
So still service report is awaited. We'll have to wait for some time.
Sir, lordship,
Well, when did when the notice was issued?
notice was issued on
Only 25
25.
May, we're in 26. Just 1 month only. Not even 1 month.
Then
Office note dated, heard Mr. Regum R. Nabam, then counsel for the petitioner. Petitioners,
Yes,
petitioner.
petitioner.
Miss P. Pango, London, is state counsel for respondent. Office note in state respondent, huh? Office note there is 17/06/25 indicates, reflects that service report in respect of respondent 7 to 14. It is still.
Lordship, in the meantime, I'd like to pray for interim because the respondent authority has issued a impugn LPC by violating the 99
We'll see. Let the, after to list the matter after 3 weeks.
3 weeks.
We'll consider.
Lordship.
Oblige, your lordship.
Yeah, my lord.
Yes.
For this.
Who has to dispose of your representation?
No, my lord,
Deputy Commissioner.
Deputy Commissioner or the Union of India?
Deputy Commissioner.
my lord, we may come to the facts, my lord.
Huh?
May I come to the facts, my lord?
What facts?
My lord, this,
What is the final decision, meeting of the,
my lord,
after discussion?
This is the copy. They agreed to the proposed made by the DO, my lord. So direction can be given for re-verification as per the procedure established by law, my lord, using the instrument. My lord.
no, my lord, on the base,
Please report this, sir, so,
Short language, my lord. May I read, my lord?
Hmm.
Please refer to sir, so committee, Tawang letter number so and so, dated so and so, copy and close. Also received by your office by DC Tawang, office letter number so and so, dated so and so on the subject. The consequence to call for a protest by the Sir Tasho committee on 6th September 2024. A meeting was called for by the station commander with Chairman Sir So committee at the station headquarters Tawang, and concerns of the committee looked into. Subsequent to the meetings, the committee has withdrawn its call for the above mentioned protest and has requested for the following: the incomplete long pending joint survey, joint land survey in respect of the 1,450 acres of defense land at Tawang be completed or reconducted. Madam, this is first thing. We have to, madam, carry read. And another is DCP S mode of survey would be acceptable to the
So committee to enable an early completion of the
Yes.
survey.
With this
No
direction,
construction
madam,
on.
mandatory.
Or will be
Subjective.
obtained on initial from survey or local. No construction of the, what is, on
Madam,
to
this
is
is
what?
not related, madam. Only one.
No, we are obtaining NOC from the Sartose committee or the locals, the chairman request sensitize I. What is this?
Okay, this is, madam, in respect of the construction work, madam. But the problem is, madam, area, madam. Once the survey is carried out, madam, the area survey carried out by the, madam, the district administration is not accepted by the, madam, DO, madam, this group. And they are proposing using other method of, madam, survey, carrying of the survey, and we are, madam.
You have accepted?
no, my lord. We have not
Committee
ac-
has accepted.
No, my lord. I have been informed, they have not accepted. This is the wrong information, my lord. We have not accepted.
What you have not accepted?
This DGPS method, my lord.
Huh?
DGPS method, my lord.
Huh?
They are saying that we have accepted to the DGPS method, the GPS system. We are not accepting it, my lord.
Huh?
We are not accepting to the GPS, my lord.
How you are, what you are accepting?
Chain and compass mode. That is why, my lord, may please come to page 133, my lord, of the rate petition. There was a meeting, my lord, where it was decided that my lord, the
Have you
verification
filed
would
the
be done.
affidavit? Have you filed the affidavit?
File, we have already filed.
133, my lord. We have submitted representation to the chief minister, my lord. Now this committee was formed, my lord, under the chairmanship of chief minister, my lord, and the chief secretary, my lord, and the representative of the government of India, my lord. My lord, may see, my lord. 2, my lord, starts from 2, para 2. They are claiming that they want to survey it from the DGPS, my lord. DO informed that he has been instructed to carry out DGPS survey of all army assets in Tawang district, and same needs to be completed within September. However, considering the divergent claims by the army and the district administration with respect to demarcation and boundaries, it was observed that going for one more unilateral survey using RTK would not be prudent at this juncture, as it would further lead to misleading data. As such, it was decided that such RTK survey should not be carried out at
What
this
is
stage.
RTK survey?
Malud, they know, Malud. Para 4 would be the relevant part, Malud. It was decided, Malud, that there is an urgent need to carry out re-verification of the army land jointly by DO and the district administration. Also, to avoid discrepancies in the outcome of such verification, it has to be done adopting the same methodology, Malud, which was used at the time of land acquisition in the year 1987 and 88, that is using compass and chain. Malud, what happened, Malud, in the year 1987, Malud, and 1988, Malud, they have acquired our land, 1,450 acres, Malud. Now, subsequently, they have been encroaching our land, Malud. They have encroached, Malud, more than area. Now, Malud, the verification was conducted by virtue of this minutes, Malud. Now it was found that they are in occupation of 1648 acres, my lord, which is access to 198 my lord, acres extra, my lord, in their possession, my lord.
Verification has been done.
Yes, my lord.
Where it is?
My lord, let's see to page 140, my lord.
Chain and compass survey.
In the small, my lord, here, my lord, total area details, my lord, in the right side, my lord,
Where?
of the box, right side of the box, my lord, on the top, my lord, area details, my lord,
Where page?
page 140, my lord, 140. My lord. This is not disputed, my lord. Total area surveyed 1648 acres, my lord. This is not disputed by the state government, neither by the Union of India, my lord. So, my lord, if they want to resurvey, yes, we are ready for resurvey, but on the basis of chain and compass mode, my lord. And on the basis of original map, my lord.
Where is this? Page 140? Where do we
140
get it? How
in
do
the-
how do you know that these are access land?
My lord, area details, my lord, in the right side, my lord, 1648 acres, my lord, which they are in occupation now, my lord.
Then
This was verified by way of chain and compass mode, my lord.
where it is?
Total survey area details down to the below to the area details, my lord. Total surveyed area 1648 acres, my lord. It is also in the affidavit of respondent number, my lord, the Union of India, my lord. It is in page 48, my lord. Page 48, my lord, of the affidavit in opposition of respondent number 123, my lord.
So they are not accepting this survey.
This is the only.
My lord, what we are submitting, my lord, is that it was decided, my lord, in the minutes, my lord, chaired by the chief minister, my lord.
Something different.
It was decided, my lord, page, my lord. Page 48, my lord. Third number, my lord. Total area surveyed 1648 acres, my lord, which was done by chain and compass method, my lord. So we are saying, my lord, that if re-verification has to be done, it has to be done by way of chain.
I'm asking what is the access land which you are claiming?
Yes, my lord. It is 198 acres, my lord.
Where? From how do we know?
My lord,
That is why I wanted to know.
that is why, my lord, I want to take, my lord, my writ petition, my lord. The land acquisition, page 126, my lord.
Total area survey.
Page 126, my lord. In the year 2nd March 1988, my lord. Page 126, my lord. One, 2, 6, my lord. Yes, my lord. This is the notification, my lord. Gazette notification, my lord. Of 22 March 1988, my lord. Schedule of area, my lord. My area is first, my lord. Serial number 1, my lord, first. Tawang, my lord, Chujajiji. The total area of 1450 acres was acquired, my lord. So, my lord,
Total survey area
is
comes to 600.
1648 acres.
From this 11450.
Yes, my lord. Now they are in occupation of 648 acres. Now 198 acres is extra, my lord, within their occupation. 198 acres, my lord. So I am ready for their prayer, my lord. Let the direction may be given for re-verification, but only on the basis of original map and the chain and compass method, my lord.
What is the problem? If
GPS, my lord, I have one, my lord. I want to demonstrate one thing, my lord. Let me, my lord. My lord, see, my lord, if, my lord, if an area, my lord, this is a flat area, my lord. If an area land is sloped, my lord. So in the chain and compass method, every area of the land is, my lord, verified, my lord. Now, by way of GPS, my lord, they erect one post here, my lord. Now, this would be parallel, my lord. So this area will not be calculated, my lord. This area, my lord. But by way of chain and compass method, my lord, this area of land will also be calculated, my lord. But by way of GPS, my lord, this area will not be calculated. So, my lord, in the year 1988, my lord, the area of land was acquired by way of chain and compass method, my lord. So it has to be, my lord, re-verified as per the original method, my lord. By way of chain and compass method, my lord. That is our submission, my lord.
Why you don't want to go the chain and compass?
That is the old method of the mapping the lane. Now the Indian Army is using the sophisticated the technology, how to measure the area. So therefore, this GPS was used. And
But then survey is, if you, there's a difference in if you survey through.
GPS, yes. We are losing 30 acres, my lord.
Yes, as per their claims, if all method is used, definitely that differences will come. But our contention is if this sophisticated technology is used, accurate area will come.
No, then we are losing land. There will be shortfall of 30 acres or 34 acres, as stated by them.
In that case, if the area done by the measured by the district administration is not satisfied by the DO, Union of India, or the area which is under the position of the Union of India by local military authorities, then in that case, the best appropriate authorities would be only to civil suit for measurement. Otherwise, it can be re-verified again by accepted procedure, by adopting the same procedure. So therefore, all this will be done by the Defense Commissioner, being the land collector, without prejudice to the petitioner as well. Of course, we understand if lands are being taken by the local military authorities without compensation, if excess area is taken and occupied by the, it will be concern for them. But our contention is that area which is under the position and occupation of the Indian Army is this much of land. There is no excess land, and 198 excess shown to be shown by the petitioner is not correct. These differences comes only when they adopted their old method of the mapping and the measurement.
What the state government is using for measurement?
The government is a chain and prismatic compass.
Huh?
Chain and compass.
Prismatic compass.
My lord, in their para 6, my lord.
But the problem is again, my lord, this was this survey was done back in 22. Later from this, Union Minister was November. For re-verification. It is like page 7. Letter was not seen.
If matter can be disposed of giving directions to the deputy commissioner to carry out the area as agreed by the parties.
Well, as per original, my lord, methodology, not the new, my lord, because
No, how we can
How
direct
can you
original or why you are not using the latest technology?
latest
That is
technology, my lord,
We'll
Well-
just say
That's right.
the deputy commissioner have a re-verification, providing opportunity to the army and the new
Petitioner.
My lord,
petitioners. That's all.
my lord, this
Will
meeting,
not say which this thing the equipment has to one. We expect
When will
that
be always
it has to.
iterative.
my lord, we are losing land, my lord. We are losing that in the GPS
How can
methodology, my lord, we
GPS
are
how
losing
can
30 acres, my lord.
Sorry.
My lord, slope area, my
Will not say.
lord,
Will
Tawang
not say
area is
which
not,
method you should be used. We'll go direct them to have a verification. Right? That's all.
my lord, what I am submitting, my lord. Tawang area is not a plain surface, my lord. It is a sloping area, my lord. Ups and downs is there, my lord. Now, by way of GPS, my lord.
If it's ups and down, it will not be.
So, my lord, the land, my lord, the surface of the land, the structure of the land is, my lord, verified, my lord. It's
That the
calculated.
deputy commissioner will know. See,
My lord, my lord.
the authority of the state will see who has to verify, who has to decide this.
And my lord,
We cannot compel them to use the old method, ignoring the latest technology. Rather, we should go for the latest technology.
My lord, what we are, my lord, submitting is that, my lord, by way of, my lord, GPS, we are losing land, my lord. My lord, in
How
Tawang,
this
there is no
possible?
land.
That means you are saying that the latest technology is not reliable.
My lord, chain compass, my lord,
Whatever, we're not saying that the GPS or whatever.
my lord.
But then we must accept the latest technology.
But the technology.
It's up to Deputy Commissioner. We'll make it clear. Which method the Deputy Commissioner will use, it's up to them.
My lord, in that case, my lord, as per original map, my lord, that may be as per original map.
We're not saying anything because it's a disputed now. Right?
My lord,
Therefore, only to find out what is the exact, what is the actual position.
my lord.
They will direct the
What I'm submitting is that, my lord.
Deputy Commissioner to look into it and re-verification.
My lord, what I'm submitting is that when they have acquired our land in the year 1988, my lord, they must have prepared a map, my lord. So on that basis, my lord, on that basis of map, my lord, the re-verification.
What is this? What the basis? See, you have shown it already. The acquisition is of
1988, my lord.
what it is? Page?
Page 126, my lord.
126 is of 126.
Yes.
Is 1,450 acres. Huh?
1,450 acres, my lord.
Yes.
Yes. Ma'am.
Then you have shown some this 140 is what? By whom?
140, my lord, is carried out by the agency, my lord. One agency, my lord, which was, my lord,
Who has engaged this?
my lord, the Director of Land Management, page 135, my lord.
1640. Huh?
Yes, my lord. This was engaged by, my lord, the Director of Land Management, page 135, my lord. Third party, my lord, MSESET Survey Consultancy and Allied, my lord. UPR Road, my lord, Boru. The third party agency was, my lord, given the charge, my lord.
So you are agreeing to this?
Yes, my lord.
And defense?
Defense said the GPS, my lord.
Our contention is only by using latest technology, madam. If verification is done, everything will be clear. That is the only one. And the axis area which they have shown by using the old method is not acceptable. Madam. It's because it's rightly pointed out by the petitioner. Madam, the area is huge and there is so many slopes area and so hilly areas, madam. That can be only possible when madam, the new method of the new technology is used. Madam. Otherwise, madam, the old method of technology by the CNS and compass system, madam, areas will be again different. Madam. On many occasions, madam, if carried out several times, madam, the difference will come.
No, my lord. Chain and compass is the practical thing, my lord. Practical way of measurement, because it was done during 1988 also, my lord.
And my lord, GPS systems is being used by the deputy the land management department in other cases also.
Presently they are doing, but what we are submitting is that, my lord, it should be done as basis, my lord, as was done in the year 1988.
No, how this has been done? Page 140.
It was done by way of chain and compass, my lord. Chain and compass, my lord.
We are not. You'll have to.
My lord, in
whatever method they used, whatever is.
My lord, page 133, my lord. Page 1, minutes of meeting, my lord. Here, my lord, it was decided, my lord. Serial number 4, my lord.
You can have this kind of decision.
So it was my lord, meetings of mind that it was agreed, my, between the Union of India Defense, my lord, state government, my lord, and the beneficiaries, landowners.
If you go by this method and stay, there is no requirement re-verification.
They are, yes, my lord.
By this minutes of the meeting, you have agreed.
Yes, my lord.
Page 133.
133.
Sorry, 133. This was in the year 2021. After 21, subsequent development took place.
What subsequent development?
Subsequent development, this has not been agreed and accepted because this has been done as per the matter. Had it been the if method and the other technology is used, we could have agreed and accepted the matter.
But we are representing 28 villages. So in Tawang, there is no more land available. We are losing land. There is a population explosion. We do not have any land. We need land.
Not Mr. B. Pitcher, Land Council for the petitioner. Petitioners.
Petitioners.
And also had Mr. Who is the
I'm for the respondent number 1, 2, 3, and 4.
the M. Kato, Land Council for the Land DSGI. For respondent number?
1, 2.
For respondent Union of India and Mr. or the Enlong London Council for the London London Senior Government Advocate for state respondents.
DSJ would be also for 4. The commander. 1, 2, 3, and 4.
I said the state Union Respondent Union of India. Huh?
Yes, sir.
By next para, filing this writ petition, the petitioners who belongs to
Sarsho community.
Sarsho, SHAR, TSO, community of Tawang district of Tawang, located at Chuje, Gigi.
The land is located at Chuje, Gigi. We are from 28 villages.
For a direction to the respondent authorities to. You have prayed for compensation only.
No, either to vacate the land or to pay compensation. But actually, we want the land.
Pay compensation to the adjacent area of 198 acres of the community land as per the right to fair compensation so and so 2013, page 35. Right to fair compensation and transparency and so and so.
Or vacate the land.
Leaving the after sparing some holy places or vacate the land after payment of adequate lease compensation for the period of the occupation. The briefly put the facts of the case are that the petitioners are the petitioner belongs to
Sarsho community
Yes.
consisting of 28 villages. Consisting of 28 villages.
How many persons are before this court?
10, my lord. Eight of them are Gaura.
Church community of Tawang representing the 28 villages.
28 villages.
Are the land owners of the land located at where? Suje, huh?
Suje Jiji, yes.
Suje Jiji Tawang. Please, Steph. The army, the Indian army, the land under on which the Indian army is occupying is the common land of Sarso community. List of Sarso community SHAR, huh? Then space TSO. Sarso community, which is located at Chuje Jiji Tawang. List of the army authority and the Indian army have been allotted 126.
126, my lord.
Allotted an area of 1450. It's Suji Gigi. List of by notification dated 22/03/1988. List of. Have you received the compensation?
Yes, in the year 1988, yes.
88, for which a compensation has also been paid to the Sarso community.
Yes, my lord.
List of. Next paragraph. It is contended on behalf of the petitioner, contended by the petitioner that when the people, when they found that the Indian army is occupying the Indian army is illegally in occupation of the land of the petitioner as Suje Jiji,
yes,
area which belongs to the petitioners, comma, a representation in excess of the allotted land of 1460 acres. But the petitioners have approached the state authorities, the state authority, approached the responding authorities by way of representation from time to time. Mr. Finally, in the, where is that the
133, my lord.
a meeting was held under the chairmanship of a coordination meeting was held under the chairmanship of the Honorable Chief Minister of Arunachal Pradesh, attended by the Chief Secretary, GOC, along with senior officers from Government of Arunachal Pradesh, officers from Pound 5 Mountain Division on 21/09/2021. Mr. In the said meeting, the defense state officer
Yes, sir.
informed that he has been instructed to carry out DGPS survey of all army assets in Tawang district, and the same needs to be completed within September. Mr. However, considering the divergent claims by the army and district administration with respect to the demarcation and boundaries, it was observed that going for one more unilateral survey using RTK would not be prudent at this juncture, and as it would further lead to misleading data. As such, it was decided that such RTK survey should not be carried out at this stage. Mr. Therefore, it was decided that, and it was decided that, no, Mr. It was further decided that to carry out re-verification of the army land jointly by defense state officer and the district administration. There is an urgent need to carry out the re-verification of the army land jointly by the DEO and the district administration, and also to avoid discrepancies in the outcome of such verification. It has to be done adopting the same methodology which was used at the time of land acquisition in the year 1987-88, that is using compass and chain. You said before that in inter alia, in the same meeting, it has been decided inter alia, because this meeting is page 133. You take it. That would be, there are 2 and 2, 3, 4. Next paragraph. Mr. B. Pitcher, counsel for the petitioner, while referring to the sequence of proceedings by the state respondents, submits that finally a survey was conducted by
joint survey, my lord.
Finally a joint verification of various pockets of defense land at Tawang by all the stakeholders were carried out. List of inter alia. It has been found. List of in respect of the land of the petitioner, the total surveyed area has been found to be 1.1648.00 acres in respect of Suje
yes,
location, which belongs to the petitioners. Since the Indian Army has been allotted for an area of 1450
Yes, my lord.
acres of land. There's an excess of 198.
Yes, my lord. Acres.
198
Yes, my lord.
acres. Accordingly, the petitioner, the petitioner should be either paid compensation, land compensation in terms of the so and so 2013 Act of 2013, or to vacate the land and revert the vacate and revert the land back to the petitioners. Next para. There's your submission. That's your submission only.
Yes, my lord. And
Because you are relying on the survey re-verification.
Yes, my lord.
So on 188, you want to back it. Either you pay it. That's
Vacate, my lord. Yes.
next para. What is your stand? What is your stand?
State is actually measuring 180, but according to the defense, it comes to 30.786 acre.
3786 means
There's a
Acres.
shortfall.
Shortfall.
As per GPS, there is a shortfall of 30.784 acres, my lord.
so. What is your stand?
So our state is, I mean,
You are the one who has engaged
During-
this survey, this third
as per
party.
this report is by this thing also, our DC, I mean, there is excess of 198, I mean, like.
This is saying so.
Yes. Acres have been occupied by.
Mr. Hud, no, Mr. Which one? You are one. Mr. D. M. Kato, DSGY for the respondent Union of India.
1 contented by filing affidavit that there is a shortfall.
Yes, sir. You just tell us. Commence that.
Our contention is original allotment is 1450, 1450. And as per our record, as per that the measurement,
If there is a shortfall of
30 point
30, 30,
37.84 acres.
37 point
30.784 acres.
0.7
84.
84 acres.
Yes.
In the area, in this area only.
This is less.
Which is through GPS, one. GPS.
Whatever.
Through GGPS.
Submits that.
As per the latest.
The-
like the.
Petition, the Indian Army admittedly the Indian Army has been allotted an area of that 1450 acres in the year 1988, 82 or 88,
88.
88, for which the petitioners have been fairly compensated in accordance with the law. Please stop. On re-verification,
It comes to
there is a shortfall of 30.784 acres out of the allotted area in the Suje GG location.
Re-verification.
Therefore,
Re-verification through DGPS, my lord.
whatever their submission is,
Instead of defense.
we'll take a call on that. Therefore, Leonard DAG submits that since the verification, re-verification carried out by the army authorities shows the deficit or shortfall of 30.784 acres, and the claim by the petitioner of the excess occupation of excess area of 198 198
190.
acres as per the re-verification oblique survey made by the third party on being engaged by the state authorities.
Yes.
comma,
By using compass.
by using compass and chain, which is outdated and old method, huh?
Yes.
Obsolete obsolete method, comma. The re-verification would be the best possible way. It should be the best way out to resolve the issue by using the modern technology or modern oblique latest technology. Huh? Please stuff. Then what's your Mr. N. Law London Senior Government Advocate for the state respondent submits that. As per the minutes of the meeting headed by the Honorable Chief Minister of Arunachal Pradesh, along with the representative GOC and the state officers of the state authorities and the army authorities. The state has engaged one Messrs. ESET, Asset Survey Consultancy and Allied, UP Road, Papumpara District, for re-verification by using the chain and compass survey, chain and re-verification and survey by chain and compass method. By using the chain and compass, accordingly, as per the re-verification, the total area comes, total area under occupation of the army, the Indian Army is 1648.00 acres. And the original allotment is of 1450 acres. Huh? Therefore, it appears that there's a difference of the excess of 198, 190 or 98, 198, 98 acres, 8. Mr. However, the verification made by the re-verification oblique the survey done by the army authorities shows that there is a deficit oblique, there is a shortfall of 30.784 acres. Therefore, he also submits that proper re-verification would be the way out to resolve the issue. I have considered the submissions of Learned Council for the parties and also furnish the materials available on record. The Indian Army has been allotted an area of 1450 acres in the located as Chuji, CHUJJEE, that will be page 126, huh? GG, huh? In the district, at Tawang, which is claims to be a land of, which is originally claims to be the land of the petitioners, consisting of 28 villages of Tawang district, of Tawang, huh? Mr. The on the considering the no, the authorities, the state authorities, including the authorities and the army authorities, has held a meeting considering the land acquisition issues pertaining to Indian Army in the district of Tawang, Arunachal Pradesh, which was headed by the Chief Minister of Honorable Chief Minister of Arunachal Pradesh, whereby decisions were arrived, among others, has decided that there is an urgent need to carry out re-verification of the army land jointly by Defense State Officer and the district administration. And to avoid discrepancies in the outcome of such verification, it has to be done by adopting the same methodology which was used at the time of land acquisition in the year 1987-88, that is using compass and chain. Mr. Pursuant to the said decision, the state authorities has carried out the re-verification, which appears to have done through the third party, namely Messrs. Asset Survey Consultancy and Allied, UP Road, Consultancy Allied, UP Road, Borum, Papumbar District, Itanagar. This stuff. The next paragraph, the survey report and the what do you call it? 140 is called, what is called? It's a map survey. My lord, what do we call it? 140? It's a map or something like.
It is a map, my lord.
It's a map.
Yes, my lord. Well, my lord, this is, yes, my lord. Map with the point of the area, my lord. This is a map, my lord.
The survey report and the joint survey report verification and the re-verification report shows that the total survey area is of 1640 48.00 acres. List of total survey in respect of Chuji Gigi land, huh? Shows the total surveyed area to be 1648.00 acres. List of the petitioners has based their claims to state that since the total surveyed area comes to 1648.00 acres, and the original allotment area is of 1450 acres. There is an excess of 198 acres, which should be for which a compensation, either a compensation to be paid or to return the land to the petitioners. List of it is equally equally on the basis of the survey oblique verification by the army authorities. There is a shortfall of 30.784 acres. Since the authorities, army has been given, has been allotted 1450 acres of land, for which a fair land compensation has already been paid to the petitioners, public landowners. Please to- Having considered the please. In view of the above, it is not clear as to it become disputed issue as to which re-verification, i.e. the state re-verification or the army authorities would be correct. Is correct, huh? This stuff. It is certain position of law that the Reed Court will not embark upon the settled disputed question of facts. Listen. The projection or for that matter claims and counterclaims of the petitioner as well as the Indian Army appears to be purely disputed question of facts, as both the claims is based on the survey re-verification done through as the claim of the petitioner is based on the re-verification survey done by a third party through the state respondents, whereas the claim of shortfall of the allotted land is through the army authorities, which appears to be through what do you call GPS?
GPS.
DPS. What is
DGPS.
DGPS? What is DGPS?
Differential
It is-
Global Position System.
DPS, a differential global
Position System.
position system,
DGPS.
which according to them, which according to authorities, respondents Union of India is the latest technology.
Yes.
Which is fit to be used in the places like Tawang. The petitioners also, equally, and per contra, the petitioner claims that the use of latest technology would not be appropriate.
Yes.
Use of technology like DGPS would not be appropriate. Rather, the old method of survey
Original method.
through
Original method.
campus and what is it? Campus and chain
Chain and compass method.
would be more accurate and appropriate as the said method was used when the land was allotted in the year 1988.
Yes.
Mr. The on next paragraph. Careful consideration of the respective stance and submissions of the learned counsel by the parties, it is clear that the matter is purely a disputed question of facts as it regards to the measurement as well as the measurement of the area. This court is not oblivious. This court is not oblivious of the law that the normally the reed court would not enter into and this would not embark on to determine a purely disputed question of facts. However, since the allotment of the land to the army authorities, to the Indian Army, which has been made in the interest of greater interest of the public and the security of the state, public and state security of the country, state and country, public country, na? Security of the state, security of the country, vis-a-vis the claim of the landowners who had spared their land for the interest of the nation. This court would incline to direct the state authorities to resolve the issue by resorting to re-verification of the resurvey of the area. Accordingly, and as agreed to by the learned counsel for the parties, this writ petition is disposed of with a direction to the Deputy Commissioner. Respond will say, state authorities will say, whoever does, the state authorities to cause cause a survey, re-verification of the re-survey of the land allotted to the Indian Army located at Chuji, GG, Tawang, within a period of 3 months. 3 months. 3 months will do.
On the basis of original map, that is my prayer. Because when someone is get allotment over the land, that is
Resurvey, re-verification, rather I will direct to use the latest technology.
that is sensitive.
By using the, we'll say, latest technology.
No, man.
How can
Because
this be?
Manoj,
No.
there was a consent of mine, Manoj. There was agreement, Manoj. That
Then we'll say, re-verification and resurvey of the land allotted to the Indian Army located at Suji, GG, huh? By in the presence of by providing opportunity, or what do we say, in the presence of in the presence of all the stakeholders within a period of 4 months from today. 4 months, because it's a monsoon season.
Yes.
A season. Monsoon season is there. 4 months or 5 months.
5 months will be.
Make it 5 months. It will be difficult. From today. With predestination and such.
Manoj, as per on the basis of original map, Manoj, because original map will identify where the land.
Obviously, I
original.
don't have to tell everything.
If this
The
observation-
authorities for re-verification, what they rely, what documents they rely, by the state authority, or what method they adopt, by what technology they use, we cannot say all these things. All right?
No.
We cannot say all these things.
Obviously.
Yes. Yes. Who is for the petitioner?
Council for the petitioner absent, my lord.
It's for compulsory appointment.
My lord.
What is your distance?
My lord, his exact stand or his exact prayer was that his claim for application, my lord, was pending, my lord. Application, my lord, for compensation appointment was pending, my lord. We have filed affidavit, my lord, that was disposed, my lord, in according to the law, my lord, in terms of the law, my lord, already, my lord, must be permanent.
No, he's seeking compulsory appointment. Huh?
No, my lord,
Who is appearing? Lawyer? Who is the lawyer? The scheme applies to her or not?
appraised, my lord. We have filed a place on record, my lord. We
It
have
applies.
disposed his representation also, my lord.
Saying what?
Saying that, my lord, at page of 88, my lord.
88.
88, my lord. Annexation number A, my lord. A series, my lord. May I read with this, my lord? With reference to above cited letter on subject, it is to inform you that as per memorandum issued by such and such, 27 July 2006, dependent family member of deceased, injured, disabled, temporary worker staff shall not be eligible for compensation appointment, but compensation under Workmen Compensation Act 1923 shall be applicable for them. A copy of memorandum is enclosed for herewith for you ready reference, please. This is
what
the
is-
memorandum of 2006, my lord.
So the compensation of the scheme appointment shall not apply,
Not applicable.
but the worksman compensation, that's the obvious thing. What is to be done in that case?
We have already informed him, my lord, but then he filed this writ petition, my lord.
Who is appearing for her? Who is Margaret Lombe?
My lord.
We'll take it up tomorrow.
Tomorrow, my lord,
If they, or Friday, if they remain unrepresented, we'll dispose of.
My lord, I believe, my lord, he is out station advocate, my lord. This petition counsel, my lord.
Margaret Lombe,
My lord.
from where?
I heard, my lord, he is practicing the Supreme Court or in Likavali, my lord. I am not sure, my lord.
So should we, what is to do? It's a claim for compensation appointment, what to do?
My lord,
We'll say, let them come back.
that one. Let's.
Note
week, my lord.
appears for the petitioner on call when the matter is placed up. What to do?
Please after 2 weeks, my lord.
2 weeks or we'll dismiss for default?
Not this, let it be 3 weeks, my lord.
Huh?
Let it be 2 weeks, my lord. But it is past non-appearance, my lord.
Mr. L. Permit, London Standing Council for Department is present. Next paragraph. Considering that the matter pertains to claim for compensation appointment, as a in the interest of justice, another opportunity is granted to the learned counsel for the petitioner. Then counsel the petitioner to argue the matter. And no, learned counsel for the petitioner. Accordingly, list this matter.
2 weeks, my lord.
After 2 weeks.
I will listen.